Okay, we're going to take a few cases out of order here. That's assuming there ever was an order, but let's go to position 9, Gregory King.
Yes, Your Honor, and I am the American Sign Language interpreter for Mr. King for the court.
Okay. Give me 1 minute here. Yes, you do. You absolutely do. And yes, I'm going to swear her in. So give me a minute here.
How you doing? The probation officer.
Well, I didn't even notice him.
Yeah, I've never been in court.
I not even sure what to say. My wife would probably agree with you that I don't notice shoes much. Let me pull up this case real quickly here. Okay, let me first swear you in. Do you solemnly swear or affirm that you will faithfully translate into sign language from English the proceedings before this court in an accurate manner, to the best of your skill and knowledge? Okay. All right, this is 22 SC 182955, Gregory King. And he is joined with his attorney. What?
He has not arrived.
I'm on.
The attorney's
Judge.
by Zoom. And your name is Euphemia Cabrera de Moore?
It is, Your Honor.
Okay. And then who has this with the state?
Morning, Your Honor, AD Ocam.
Okay. And Ms. Oakham is also appearing by Zoom. So, Mr. King, your attorney is on Zoom. And you also have an interpreter. So what, if you have any questions or comments or concerns that you need to, I want you to raise your hand or alert me, and we will arrange for you to be able to speak privately with your attorney. You understand?
Yes.
You'd like to speak with your attorney? Okay, Ms. Cabrera de Moore, we're going to need to figure out, arrange for you to be able to speak with the defendant. Fortunately, he's not in custody. Go ahead.
Right.
What were you going to say?
So I was going to ask if we can make an announcement. This case was on the calendar before in July, and we were set for 30 days because he needed a sign language interpreter. So it was kind of difficult for us to move forward at that time. And so Your Honor reset that so that we could have someone present. I think he's on for case management. I have his discovery. I have his offer. the next thing would be, what's the best way to communicate with him about his case and to discuss his decisions moving forward? Considering he needs a sign language interpreter for us to communicate with one another.
What was that, Kathy? I see that. It's a co-defendant case.
Mhm.
My problem is now, as your attorney just stated, this is a case management. And so we're just discussing your case procedurally. But the larger issue is you've requested the ability to speak with your attorney. I'm not sure, since it's case management, it's urgent that you speak with her at this moment, but
Right.
we are going to have to figure out how to arrange for you to speak with your attorney with the interpreter.
And I don't know if it's possible for me to arrange a meeting somewhere in the courthouse where I have an interpreter present, where I can bring him his discovery, go over some things with him, talk to him about his case, because it's important, naturally, that I be able to speak with him. And I would prefer to be able to come to the courthouse and make an official appointment with him with an interpreter present, because I do have everything he needs at this point for us to move forward and figure out how to resolve this.
Well, I'm going to ask the interpreter if she has a suggestion.
Absolutely.
What have people done in the past in this situation?
Absolutely.
Been doing this for many years, and normally the attorney is already here. And the attorney, I interpret between the attorney and the defendant in a separate room, and then we come into court. So if you wanted to postpone, I don't know if he needs to come back to see you again, but they can always make an appointment for you, right? In order to have the interpreter come back another day and time for a meeting with the attorney. And then you can come in and, right afterwards, see the judge if that's what needs to be done. But if all he needs to do is confer with the attorney, then the court would need to request that to happen.
I don't know did you catch that, Ms. Cabrera?
I did catch most of it. It sounds like she needs to, typically that we're all in the same place for a calendar. My preference would be that it's not a calendar day. If at all possible, is there any way that I can coordinate with her office to schedule a meeting and I come to the courthouse and meet him someplace on one of the floors to talk with him? Because if it's a day that we have court, then if there's a decision to be made, he's put in position to make a decision on that day. And that's unfair to him.
Okay, from my experience, the court can book the interpreter for a private room for him and his attorney to have a meeting. And then we can come into court another day if need be. But that request would need to be made through the interpreting agency, not through me individually. And so she can, I'm sorry, I don't know. Okay, Ms. Robinson would be able to call the agency to make that happen.
Okay. So I want to make sure Mr. King understands what I'm going to say here. So what we're going to do then, because we do need to move this case along, but obviously Mr. King has a right to speak with his attorney about his case. And so we will reach out to you, Ms. Cabrera Demore, and Mr. King, and arrange a time for you to be able to meet in my jury room and you can discuss your case. Does that make sense?
That makes great sense, Your Honor.
That's fine.
Does that make sense? Okay.
Yes, I understand.
All right.
If we can get, while he's in court, if we can get his email address, because that may help too. I can also communicate with him by email, and that may help to speed up any meeting that we have in your jury room.
Okay, I can give it to you now.
Okay,
He's looking for it. Just a moment.
that's fine.
Ms. Cabrera,
Yes,
he's asking if you can communicate with him by text. He doesn't use email very often, and he thinks that you'd be able to contact him more easily by text. Is that?
I
possible?
can. That's possible. What's a good phone number? If he doesn't mind giving it.
Yes, he's gonna give it to me now.
Mhm.
404
Mhm.
492 0355.
Okay, what I'll do is as soon as we've concluded this hearing, I will text him so he has my number for sure. And then we'll just try to use text messaging and I'll wait for the court to contact me about coming to meet him in chambers. Your Honor, I do have a trial before Judge Whitaker next week that is expected to last about 2 weeks.
Okay. All right. Well, I'll tell you what, don't leave yet. Because it's obviously a multi-defendant case, and I'll go ahead and we'll take up all the defendants in this case now, just in case something arises that would affect Mr. King.
Okay.
And this is the interpreter speaking. Ms. Cabrera,
Yes.
when you text him, can you give him your full name? Because I only, and I don't know that I spelled it correctly when I spelled it to him.
I absolutely will.
Thank you very much. I appreciate that.
Thank you.
What? Okay. All right, you can be seated for a minute, and I'm just going to go through all the defendants in this case.
Okay, thank you, Your Honor.
And I guess you'll sit in an area where he can
Yes.
see you. Okay. All right. So I believe position 7, James Sheffield, 22 SC 182-955 is the first on the calendar regarding this case. Who's his attorney? Hoover? Is Mr. Sheffield present?
Your Honor, I believe there's a warrant for his arrest. At
Well,
least
that would
that's what Odyssey
explain,
shows for me.
Thank you. That would explain why he's not here. Yeah, I see it here. Okay, so he has a warrant. Position 8, Lindsay.
Your Honor, that's Marsha McNose. She's a defense attorney. I believe she filed a notice of conflict unless if she's in court that we should hold for her report. Is that her in court?
Yes, that is me, Your Honor. Good morning.
Good morning.
I have completed my conflict in Clayton and I'm here at the court's pleasure.
Well, I'm not sure we're going to have a whole lot to discuss, but what's going on with the case from your perspective, Ms. Mignon?
2 matters, Judge, that's on. I showed that Mr.
I'm sorry, Ms. Mignon, can you come to the?
Yes, that's right, Miss, because
so I
Ms.
can
Elcom
hear
is
you.
at the.
Thank you.
Thank you. I apologize.
Thank you.
I have Mr. Lindsay, Your Honor. We have pending motions and I don't believe that any of them have been heard as yet. I'm looking at my notes. And I believe I also have Mr. Willie Holmes on your calendar for a bond motion. So I have 2 on the calendar, Judge. Mr.
Okay.
John Tavius Lindsay and Mr. Willie Holmes.
All right. what are the motions that you have to be heard?
We have Jackson Dental motions filed, Judge.
Your Honor,
have
this day
pending-
would ask for a motions hearing date because I would be filing my 418s as well, and we can have all of them on the same day for all co-defendants. Just come back for a motions hearing date.
Okay, what's the other motion you have?
We also have a motion for bond, Your Honor, on Mr. Holmes, because all the other co-defendants have been granted bond, and I believe he was not able to be heard because I had a conflict at the time the court was hearing those issues.
Your Honor, that's a different case. This is Lindsay Jatavius.
Yeah, that's what I'm talking about I know we've got the bond motion. I'm talking about Lindsay. What you said, where there's a Jackson Deno. And
Yes,
what's the
Judge.
other motion? you've
Motion
got?
to suppress?
Motion.
Yes, we file a boilerplate motion to suppress. And then what we do is once discovery is served, we particularize those. If we don't need to particularize them, Judge, we withdraw them. So if we can be placed on a motions calendar, we would be ready. State, do you have the discovery and Mr.?
Yes, it was filed July 7th.
So Your Honor, was it filed with our firm or our previous counsel?
Well, let me check. It should be with you because you've been the only attorney.
And Ms. Oakham, you've either got one or you're going to have a 418 motion.
I'm going to file a 418, Judge, yes.
Okay. I suppose that's self-evident. Given the charges.
That we hold these truths. I'm sorry.
Yes, it was filed with you, Ms. Mignon.
Okay, thank you, ma'am.
Okay, I think that's a good suggestion, Ms. Oakham. And we will get back to you with a motions hearing for all of the defendants in this case and all of the motions.
Yes, Judge, thank you.
Okay.
And are we holding on Holmes, Your Honor, for the issue of bond?
Yeah. We'll get to Holmes. We'll get to Holmes.
Okay,
We'll
thank
get
you,
to
Your Honor.
Holmes. All right, so position 10 is reset. I think that's it for this case then. As far as the case management, so Mr. King and the interpreter are excused.
Thank you very much, Your Honor.
Okay,
Thank you, Judge. That completes my business. May I also be excused?
you're excused.
Thank you, Judge.
After you said we had one other interpreter case. Well, I was gonna just do a calendar call, so why don't we go? Let's go ahead and do Ramirez Herrera. Position 2.
Good morning, Judge. David West here.
What's the issue? Okay, all right. All right, where's Mr. Ramirez Herrera?
He's right here, Judge.
Where's the interpreter?
He doesn't.
Okay. Doesn't sound like you do. Well, let's go ahead and then let's just do the calendar call like we were going to do it then. All right, you can be seated. That's all right. That's all right. All right, so position 1, this is just announcements here. Puricelli.
Good morning, Your Honor. There's still a pending evaluation. I believe Ms. Jones last week while I was out had sent an order to essentially DBHDD to have access to Mr. Puricelli's medical records. So that's still pending as of the moment. So I'd ask if it could be reset for another 60 days.
60?
Yes, Your Honor.
All right, we'll reset it. Position 2, Ramirez Herrera. Just an announcement here.
Judge, we had not had discovery. I literally just got an email with the evidence.com link that looks like it was sent this morning to me on this case. So we have just received discovery. Obviously, we would not be ready this time. has to be rolled over to the next calendar.
Who has this? Mr. Bridges? Okay. So you just received discovery.
Literally moments ago.
All right, we'll reset it for 30 days.
Thank you, Judge.
You're excused. So are you. Mr. Ramirez Herrera. Position 3, Wilson.
Yes, Your Honor. Mr. Wilson is here. It's noted as a special plea of competency to stand trial. That had actually been ordered already back when this case was in non-public execution. I had filed some motions on September the 21st, given that Mr. Wilson is in custody. Saying that essentially the non-complex judge's order was that he be taken to the hospital for competency restoration. I filed a motion based on, one, the nature of the charges, as well as the fact that he had been recently assaulted at the jail, to see if he could be, that order could be modified to allow him to do competency restoration on an outpatient basis. I've discussed it with Ms. Sellers. I've been talking with Mr. Wilson's family, trying to set him up a place that he could actually stay where he could be released. I don't have that information morning right now, but I'm close to hopefully getting something. And so that's what I'm asking is, my understanding is the state may not have an objection to that. So if Your Honor would be amenable to us presenting the consent order with signature.
Ms. Sellers.
Yes, Your Honor, I have been in, state has been in communication with defense counsel regarding this matter. Seems like there would be a consent for the defendant to do restoration of competency.
And you're just trying to get him living arrangements at this point?
Just to make sure that he's stable when he gets out. Yes.
All right, give me the consent order.
Yes, Your Honor.
All right. Position 4, Williams.
Your Honor.
Okay, we'll circle back. Position 5, Vecchio.
I don't see Mr. Vecchio here, Your Honor. I'm working to get contact information for him. He had bonded out on an unrelated charge last month after being in custody for about 9 months at that point. So bail was posted by the Bail Project. I've been in touch with them of trying to make sure that we can track him down. I'd ask if this could be reset one more time. I'm optimistic that I'm going to be able to reach Mr. Vecchio based on kind of his current living arrangements of the program. Just was not able to do that prior to today.
1 minute. So I've got my notes that he had an outstanding case in Dawson County.
He had probation up there, Your Honor. What had happened was, and I guess this was a little over a year ago, when we had delayed the plea to see what Dawson County would do. They revoked his probation, required him to attend outpatient mental health treatment. Essentially, while he was waiting to get into that, he had another mental health episode that resulted in charges he was arrested for in January, and he spent 9 months in the Fulton County Jail before.
Let me hear from the state.
Your Honor, whatever the best way it is to get him here, he has a very plausible plea offer in place that doesn't require him to serve any more time. It actually just gets him into the mental health court, so, or some mental health treatment.
And I've discussed it with Mr. Vecchio numerous times in the past, we want to finalize this based on where he was at last year. So I don't think his purpose would be avoiding. So I just asked if I could have another count, 30 days even to see if I can.
Do you object to resetting it for 30 days?
Your Honor, all candor, bitch won't get him back here faster.
1 minute. What, Kathy? He has a probation warrant in Dawson County. All right, go ahead, Mr. Bridges. What were you saying?
Dawson County has a warrant, Your Honor. It's probably best if you put a warrant on him too, so once he gets to Dawson, he'll be brought here after that.
Mr. Clark?
I was just checking to make sure that he got notice.
Well,
Assuming that he had, I would leave it to discretion before just.
yeah, he received notice. All right, let's issue bench warrant and bond forfeiture. Position 6, Quayshawn Green.
I am present on that this morning, Your Honor. This case, actually, this 20 SC 174520 should have been null pros, and it should have been null pros a long time ago. I'm not sure why it's still pending. I've spoken to the DA's office several times in regard to that. It was re-indicted under 20 SC 177025, which has a status docket of 1026. There are a few motions outstanding. Your Honor may recall, we had a motions hearing in August as well.
Yeah, I see my
Your
note.
Honor, I will file a motion to null pros that. I don't know why it hasn't been null pros, but this was re-indicted under 20 SC 177025.
Okay. What was it re-indicted under again?
20 SC 177025.
Okay. All right, thanks. Position 11, Kirk.
I am present on that, Your Honor.
What?
Your Honor, I just received updated discovery yesterday. However, they provided a download link rather than a shared link from evidence.com. So I can't download it. My computer does not have enough space, or my H drive, but I'll get with the state so that they can share that with me. I don't think that'll be a big deal or issue. So we would just think that this is appropriate for a final plea and trial docket.
Why do we have bond reinstatement in the notes?
Because she failed to appear at some point, Your Honor, and you allowed that warrant to be set aside probably about a month ago, which is why I'm guessing it's case management to see where it's at. But again, I don't believe I'm going to have an issue with discovery.
She's here, so that was a good call on my part, so.
And I'm going to get with Mr. Bridges and ask him to share rather than give me the download link, because that's just an issue with computer space. But she is present. And again, I think that this is appropriate for a final plea and then trial docket. And then Mr. Bridges and I will continue to discuss potential resolutions.
Okay, let's go ahead and put it on a final plea and trial docket then. See him is excused. Position 12, Lamarian Lawrence. Looks like he's a co-defendant with Jeffries.
Good morning, Judge. Ricky Richardson for Omarion Lawrence. Omarion.
And I am present on Mr. Jeffries.
Mr. Jeffries here. He's in custody. All right, and so we reset this. Why did we reset it?
I'm not sure, Judge. Maybe I had a conflict. I'm not sure. You know, I think maybe before the state had different states council, I'd be guessing off the top of my head. I will say to the court that I believe that I have all of the discovery. That if not, I'll get in touch with Ms. Oakham because later this week is just tomorrow. Beginning of next week, we have some other discussions to have. And other than that, Judge, probably needs to be placed on the final plea or whatever the court's procedure is.
Your Honor, the state will be filing our 418 motions, and so we probably need a motions date first, but I will file that for the court on both cases.
And Judge, there may be, and I'll look at the discovery again this weekend, a motion to sever with regard to these two defendants. Not sure about it, but I'll go over it this weekend as well as speak to Mr. Lawrence and his mom in the next coming days.
Yeah. Ms. Jones, anything you want to add to it?
No, Your Honor, just that my client's in custody currently, and he doesn't have the benefit of hearing the status update.
All right, let's bring him out then. Bring out Jeffries, bring out Jeffries. What? I don't know. Where's Lindsay? Oh. No, it was just status. I mean, who's his attorney? Who's Lindsay's attorney? Yeah, so it's not, I mean, yeah. Now, I mean, I guess, all right, we'll bring Lindsay out next and I'll tell them what's going on.
No, they still down. That's why I was trying to do.
Oh, Lindsay's still down. All right, don't bring Lindsay up then.
Okay.
It was just an announcement. I mean, it wasn't any kind. All right, so this is 22 SC 181084. We have two co-defendants, Lamarian Lawrence and Contavious Jeffries. Contavious Jeffries is in the courtroom with his attorney, Ms. Jones. Mr. Richardson is Lawrence's attorney. He's online. And so, Mr. Lawrence, we were just briefly discussing the status updates of your case. I apologize. And we need to file a motions date for some motions that are going to be done, especially by the prosecutor. And then well, I'll let Mr. Richardson speak to it. There could be a motion to sever, Mr. Richardson.
Possibly, Judge. I want to review the discovery I have. I know there were just two defendants, but I think their posture is significantly different, at least from my assessment, without giving up more. So I'll review it with his mom, and my staff, and see what we think is in his best interest in terms of proceeding. And there will be ongoing conversations with myself and ADA Oakham, see if we can resolve it short of a trial as well.
Ms. Jones, do you have anything to add?
No, Your Honor, and just for my client's benefit, the state previously indicated that file 418 motion in regard at least to my client, Mr. Jeffries, which is a gang motion, Your Honor, to introduce potentially that information. And when that is filed by the state, I will get with Mr. Jeffries and talk about that motion and make sure he understands what's going on. So the next date for Mr. Jeffries is going to be most likely a motions calendar, which would include the 418, the motion to sever, and anything else that we think is appropriate. Okay. Nothing further.
Okay, and as Ms. Jones mentioned, the 418 is a gang motion where the state wants to introduce evidence on possible evidence of gang association. So anything else? All right, you're excused,
Thank
Mr.
you, Your Honor.
Jeffries.
Your Honor,
Yes,
may I check in with Judge Cox and I'll be back?
okay.
Thank you, Judge.
May I be excused then, Judge, and Mr. Lawrence as well?
Yes, you're excused.
Thank you.
All right, let's do position 14, Joel Wilson. No, we don't need to bring him out real quickly.
He was number 3 as well. I think this is just on the calendar twice for some reason.
Oh. Yeah, okay. Position 15, Holmes. That's right. That was the bond. That was Mignon.
No.
Mignon. She had to step out.
Yeah, she's out there. She told me to come get her with.
Well, there's no point. You know what? We're not going to hear this right now. We're going to wait until after we're done. So we'll get her when we. All right, position 16, Jeter.
Your Honor, Ms. Kaufman had actually appeared before the court earlier today. She had requested a motion to modify sentence.
I'm familiar with it.
I'm working with Ms. Kaufman to address her issue that she's raised and sit down and talk with her about that mitigation. So if we could get another date, maybe 30 days out, just give us some time to review that.
So I'm aware of the so there's medication involved.
Mitigation.
Oh, mitigation. Thank you. Thank you. I was gonna say, I don't recall reading that in the motion, but and it was a brief motion. So I was, all right. Okay. And so Ms. Kaufman, you spoke with her and you said you were going to make an announcement on her behalf and
I did. She emailed me actually earlier in the week and reached out about it, and we were trying to get on the same schedule this week, but we're unable to do so.
okay. All right, let's reset it for 30 days then.
Short of, if we do not need a hearing, Your Honor, maybe you submit a consent order for able to come to an agreement.
Yeah, you can submit a consent order. All right, so position 17, Reed. Is Mr. Smith online or around? All right, we'll circle back. All right, position 18, Young.
In custody, Your Honor.
I want to speak with, I guess, Mr. Bridges about this to potentially pre-try it. I don't believe she's up yet either, so I'd ask if we could come back to that.
Okay. Position 19, Bridges.
In custody, Your Honor.
And Your Honor, last time she was before the court, she has another pending case that she's been indicted that's actually holding her. That has been transferred over to Your Honor's courtroom now. Mr. Crail Lewis represents her on that case. So I think it would be appropriate if we set both of those down for a final plea in a trial calendar.
You have the case number, the other case?
I can get that.
Let's see, 18831.
Okay. All right, let's reset it for 30 days. And position 20, Bonner.
In custody, Your Honor.
Mr. Bonder's in custody as well, Your Honor. We had a hearing on a special demur in June on this case. And we're still awaiting a decision on that. I guess still pending Your Honor's decision. I believe I've, from what I can tell, been served all available discovery on this. He's obviously been in custody for some period of time. So I guess pending that decision, and when that comes out, we'd ask for it to go on a trial calendar, final plea trial calendar.
All right, I'll get you that decision.
Yes.
All right. Let's go through these other add-ons. Aubrey Nicole Lee, that's a bond situation, so we'll take that up.
We were gonna.
Okay.
Wait.
I'm sorry, I don't want to interrupt. I have her consent to waive her presence, so we're gonna waive.
Pardon me?
We were gonna conduct the bond hearing without Aubrey's presence. Waive her presence.
Oh, is she not, is she's here?
Oh, she is here? I thought that.
Okay.
We just ain't bring her up.
Okay.
Bring her up.
Okay. If you have.
All right, okay. And then we have Shaquan Smith.
Yes, Your Honor.
Custody, Your Honor.
We had, he has two cases, Your Honor. I've been in discussions with Mr. Bridges about resolving these. The state has made an offer on one of the positions. Let me look at the case number, that Mr. Smith would absolutely be willing to accept. With regards to the second case, the 22 SC 180-895. In my discussions with Mr. Bridges, the state's not quite ready to make an offer on that. It sounds like it would be a substantially concurrent offer to what they've made on the 181284 case. So I guess puts us in the position of, I know Mr. Smith wants to resolve this. The offer that was given to him, he absolutely wants to accept. If the other offer is substantially concurrent to that, he accept that as well. So I guess I want some direction from the court, because it sounds like we'd only be able to go forward on one today, that this is something that isn't going to result in a trial. I obviously am in the position where I would like to resolve both at the same time if we can. So I guess I'd leave it to your honor's discretion. I know he's set for one of the cases on the trial calendar on Monday, and that's the one that the state is in the position and ready to resolve. But I guess my ultimate request is maybe if we could set it for next week or the week after, just for a plea hearing on both cases, at least in speaking with Mr. Bridges. Sounds like the state would be prepared at that point. I don't want to put any words in his mouth, obviously, so.
Mr. Bridges?
Your Honor, I'd actually prefer, because the one is on the Monday consolidated trial calendar, it's actually number one, pretty much. So I'd like to get that one resolved. And then, as I told him, I must speak to the victim in the second case and get her on board in that case. And the victim in that case is his mother, I mean, but she's been steadfast in her position. She hasn't changed. So I have to talk to her about possible resolution in the second case.
So the 895 case is teed up into one position for the consolidated trial count.
The 284 is the one that's number
All right.
one.
And so, Mr. Bridges, your preference would be to do the plea on that today and then schedule another day for a plea for the other one. Well, I think given the fact that he's teed up in the consolidated trial calendar, I mean, you're going to end up, it's going to be a little less efficient, but that's what I want to do as well. If your client's, is he ready to take the plea on that?
Yeah, I'll have to do the paperwork with him,
right.
obviously, but have a moment to do that. But yeah, I'll go discuss and we should be able to resolve. it
Okay.
today.
All right. Is there anything else? Oh, we've got the motions hearings on, pardon me? That's at 1? I've got it down for 9:30 here.
Oh, sorry.
For the 20 SC 177025 case. Are they present? And I saw Oakham. How about the attorneys?
For Rosen Bay,
Yeah.
I have not seen Ms. Compton and Ms. Sean Hoover has to go.
Okay. All right. So Shaquan Smith's going to be a plea. Aubrey Nicole Lee. Shart's still around. That's at 1, right?
Yeah, that one's.
Okay. All right, well, let's do the two bonds. Is McNaught?
Yes, Judge.
All right, let's go ahead and do bond on your client Holmes. Go ahead and bring out Holmes. Who's got this with the state?
88 Bridges, Your Honor.
Okay, I see you were standing, Miss McCauley. What?
Yes, Judge, my business is concluded. May I be excused?
You're excused.
Thank you. Well, Your Honor, may I be excused?
You're excused, Miss Sellers. And Miss Marsh, which case are you waiting on again?
Honor, I am position number 4, Vincent
Oh, that's right. We're waiting on Shart for that.
Your Honor, Spanish interpreter for position 2.
It turned out he didn't need he speaks better English than I do.
There you
So. All right. It's a bond. There's an issue with the bond. The state added charges, and so it did. I don't know what it is, but we're gonna bring them out and it's fine. It doesn't matter. It's a bond issue. Okay.
All right, we're here on a bond motion. Just gonna make a determination.
Yes, I printed these.
How old are you? Do you have any kids?
Yes, ma'am.
How many? 2 children? How old are you? How old?
16 and 14.
Who do they live with?
Right now, they're both.
Where were they living when you were arrested?
1812.
Well, we were like co-parents and they come.
Okay. And where were you residing before you were arrested?
Yeah, because Bumpus and then Brandon is the other
Gonna go
attorney
back to
in
Smyrna.
this, on the 418, on the Vines and Roads
What's the
case,
address?
right?
What's the address?
1853
Mhm.
Eddington Road.
EDING.
TON.
But Brandon filed the
Who lives
Eighth
there?
Amendment motion.
Okay. Is your mom here?
No.
Which is it?
My girlfriend. Is it legal?
Who would you reside with there?
Who resides there?
Yeah.
My mom.
What's your
Sharon
mom?
Holmes.
That's right. You can see me on there. I always wonder how you notice what I'm doing up here with my coffee mugs and my,
August 28th.
I forget about that. Spotlight
You
me.
have a bond?
Everybody else pays for it.
Okay, what are they? You think you can make that?
Eventually, yes.
Ever been arrested?
Yes.
How many priors?
A lot. But no violent, bro. Just nothing.
Well, because I'm not owning up to the
Drugs.
fact that I need to upgrade my glasses.
Nothing else.
I'm gonna have to
you
get
some
the
treatment?
Coke bottles pretty soon.
What's your highest level of education?
I got GD.
Okay. All right.
It's bad when you have to wear contacts and the glasses. All right, you ready, Ms. McNaught? Or
We're
you
ready,
got a little
Judge.
more time? All right, so this is 22 SC 185413 Willie Lewis Holmes, who's present in the courtroom with his attorney, Marcia McNaught. And then we have Mr. Roderick Bridges representing his state. Ms. McNaught, you have a motion for bond.
Yes, Your Honor. Mr. Holmes is sitting with no bond currently. August the 28th of 2022. We are respectfully requesting that the court set a bond in this case. There are 3 other co-defendants, and based on correspondence with my client, all 3 co-defendants have been granted bond in this case. He has 2 minor children, 16-year-old and 14-year-old, who is responsible for the care and maintenance of. He would be residing with his mother, Miss Sharon Holmes, in Marietta at Eddington Road, where he was residing prior to these charges. And he's 35 years old, Your Honor. He has a GED. He can become gainfully employed if the court sets that as a condition of his bond. And we would respectfully request that the court grant a bond in this case for the dollar amount of $150,000. Unless the court deems a lower amount necessary.
1 minute here. All right, Mr. Bridges, go ahead.
Your Honor, we respectfully request that Mr. Holmes remain in no bond status. He has a horrible record.
Can you pull the mic over?
I'm sorry, it's not on. He has a horrible record, Your Honor. He has over 15 cycles. He has 6 felony convictions, serious drug offenses out of Cobb County. In addition, he has several probation. He has a probation revocation, Your Honor, in which is part of his sentence was revoked. This was a horrible crime, Your Honor. The victim in this case, they pulled him out of the car, pistol whipped him. When he attempted to run away, they actually shot him, leaving him paralyzed for some time. He has regained some feeling in his legs, and hopefully he will have a full recovery. But based on the incident, Your Honor, his criminal record, the crimes, and the danger to the community, I'd ask that he remain in no bond status.
One minute. All right, well, Mr. Bridges, his codees have bonds. I know the state may have disagreed with that as well. I can't remember. One of them's fairly minor, 2 of them, one's 150, one's 156. One was given by me and one was given by Judge Manning. Do you have any comment on that?
Yes, Your Honor. You look at the criminal record of the co-defendants. I think one has 1 cycle, the other one has 3 cycle, and the other one has 1 cycle too. I don't think they have any felony convictions.
And how many felony convictions does Holmes have?
6.
And I think, Your Honor, the 90-day rule might apply in this situation, even though the case has been indicted. Looking at the timeline in the docket.
When was he indicted?
Give me a second, Your Honor.
Oh, wait a minute, I see it here. Strange. All right, well, go. I guess, Mr. Bridges, why don't you speak to the 90-day rule?
Your Honor, the defendant has been indicted. I still, hold on, let me find the date of indictment, Your Honor. Does the court have the date of indictment?
Well, I'm looking at it. It looks like the indictment was it December 12th, 2022, or was that a?
That's correct, Judge. And it was past 90 days. Because he was taken into custody, looks like August 28th, 2022.
And Your Honor, we have no motion for that before us, claiming the 90-day violation.
We did claim it, Your Honor. It's filed January 12th, 2023, was served upon the state, and it's
There's
listed.
something in there about 90 days.
Yes, it's listed in paragraph 4 of our motion.
Your Honor, then she is correct. He would be entitled to a bond. We would ask the bond at a minimum of $500,000, Your Honor.
Your Honor, we ask that his bond not be higher than Donald Trump's bond.
Is that going to be the new?
That's the new standard in Fulton, Judge.
Technically, at this point, we don't have any evidence that Trump shot anybody.
but he's killing this country.
I
Oh,
don't
my
have any
Lord.
evidence of that.
Oh, my God. No matter how hard I try, it's only 2 courtrooms down. It leaks over. It just leaks over here. We need to contain it over there. All right, well, Miss McNaught, specifically on your client's criminal history, well, look, it's your response. You can speak to whatever you want, but specifically on that, what do you have to say?
Your Honor, my client's presumed innocent until proven guilty. He retains his presumption of innocence, despite however many cycles he may have in the court system. And we submit to the court that if the standard is a threat to the community, the other 3 defendants have a bond, and they're also a threat to the community. We respectfully request that our client be treated equally, not better, and a bond of at least the same 150,000 or the highest 156,000 be granted to our client, because justice does demand that. Thank you.
So he's had 6, I'm speaking to Mr. Bridges now. He had 6 felony convictions, probation revocations. What about failure to appears?
I didn't see a failure to appear, Your Honor. This cycle goes back to 2006, Your Honor, starting in Cobb County with the purchase, possession of marijuana.
Bridges, can you please?
I'm sorry, I apologize. Yeah, his cycle goes back to 2006, Your Honor. That's how long he's been committing crimes. And it goes back to a purchase of marijuana with the intent to distribute. And it goes on. He has several of those, and those are what his convictions are falling from. Those major attempt to sell drugs.
And I submit to the court judge, looking at my client's record, it seems as if, and this is not an indictment on anyone, the system has failed him, because if he has a drug problem and that drug problem is not treated, and all we're doing is treating the symptoms of the underlying problem, then we get an individual like Willie Lewis Holmes before this court, because we are not treating the problem. So if the court is inclined to order him while on probation to get into some type of drug evaluation or treatment or something, or even an ankle monitor that would assure the court of his whereabouts, or through the pretrial diversion, they can monitor, I'm sorry, not through pretrial diversion, but pretrial services, they can monitor Mr. Holmes. We think that would be best for him, so that we can address the underlying issue, which I suspect at this point is a drug problem. And you can incarcerate him for life, but if he has a drug problem, you're not curing it unless you're treating it. No different from if he had had cancer and you lock him up, it's not going to cure the cancer.
All right, I'm going to do $300,000 bond. He will have no contact directly or indirectly with the victim, victim's family, professional, personal, or close associates by phone, mail, email, or through a third party, including victim's workplace, church, home, and daycare. If you encounter the victim, you must leave immediately and must not come within 200 yards. Let me see here. You are to have an ankle monitor. You are to have a 24-hour curfew except for medical, court, attorney visits. No contact with your co-defendants. You're not to possess any firearms or weapons. Have a drug and alcohol evaluation and follow the recommendations. You're not to possess any drugs without a prescription, and no alcohol, and stay away from the incident location. Anything else? Mr. Bridges, do you have anything else you think ought to be added to it?
No, Your Honor, I think you covered everything.
And Your Honor, with so many requirements, is the court inclined to at least reduce that 300,000, since we have so many other conditions on him, like the 24-hour curfew?
No, we're gonna leave the 300. Okay. All right, well, let's do let's do the, what's the acronym for that again? BACC?
Yes, Judge.
We'll do the BACC program then. All right. If you could submit the order to the court, Ms. McNaught.
Yes, Judge.
All right, thank you.
Thank you, Judge. I have nothing further before the court, Your Honor. Once I speak with my client, may I be excused?
Yes.
Your Honor, we need to address the case management portion of this.
Oh. Where do we stand with this case? Let's see here.
Discovery, Your Honor, is the issue. We have filed preliminary motions. They were all filed in April of this year. Once we receive the state's discovery, I believe, no, Your Honor, I misspoke. We do have discovery in this case, but I believe it's almost a terabyte. And we need to go through it to particularize our motions. If there's no need to particularize because there's no statements given by our client, Judge, we'll withdraw those motions and we'll do it on the record so the court will be aware.
How much time do you need to review the discovery?
If Your Honor's next calendar is going to be in December, we should be fine. I'm possibly starting a trial before Judge Whitaker on at 8:30. So that's the only reason I would need at least until December.
Okay. Let's put it on a December calendar for final plea. Anything else?
Nothing further on behalf of the defendant, Judge.
All right. You're excused.
Thank you, Judge.
I guess, is Lee up or is she down still?
He's down. She's got it over here. I was gonna say, Your Honor, you wanted to bring her up or you wanted to wait? To bring her?
No, if she's in the building, there's no reason to waive that. We'll bring her up.
Okay. We got room. We got room to go. Can we take anybody down right now?
Well, I think we can bring a bunch down. Is there anything we can address before I go on break? Still don't have Shard here, right?
I would just request, Mr. Green was not brought out when we gave him the status. And I know he's very anxious about his case.
Is that for Sean?
Yes,
Yeah, he's up. What about Smith?
just let him know that.
Bring him out.
Going to be 10:26.
Oh, yeah, you said Smith Saquon's taking a plea.
What?
You said Saquon Smith is taking a plea. Yes.
Yeah. He needs to stay. What position is Green?
He was position 6, Your Honor.
I'm always happy to bring them out.
It makes them happy as well, Your Honor.
Judge, I have other appearances this morning. Would it be okay if I gave my announcement to 88 Bridges and excuse myself?
Yes.
Okay, thank you.
Position, yeah.
Since I'm not sure, Max is caught up in that YSL, so he tries to sneak up here when he can, but I'm not sure.
Okay.
These days, I'd rather have that than just nothing.
Yeah, just give him an update so he knows.
Why did we reset Green? I didn't, right.
Well, this case should actually be null prost. It's the other case.
That's right. That's right.
That's the one that shut up.
It is, it's on for 10/26
Boiling water.
with his other co-defendants. Yeah, so he was originally indicted by himself and then he was re-indicted with co-defendants about 11 months after this one.
I think it was just the 3
Manslaughter.
Oh, she wants to go deal with
I'm thinking this train just keeps coming. Just keeps coming.
And I think it's.
I am. I've got a lot of emotions going in my head, balancing a lot of. I am gonna know 418 like the back of my head. Did you see 418? Did you see the cert order on that?
I didn't, I haven't had a chance, Your Honor, you keep me in here. So,
Well, they granted cert, but it's not gonna be held till next, no, hearing won't be held till next year. But they said, I forget the exact wording, but of particular interest is the nexus.
oh, okay, well, I think it's a valid concern.
The law is McKinney right now. That's the problem. Well, I know you differ on it.
Supreme Court, but I'm sure that they will provide clarification,
I think they will. I think they will.
which is always good, right? I mean, I'd rather have black letter law than gray. Even if it's on the wrong side of me, but I would rather have,
Yeah.
I would rather have the black letter law. It saves the heartburn, so to speak.
No, I know.
I like it too.
I don't know why the jail did this, but they did it. The judge.
You know, but I'm also thinking about, because I've got up on Monday and I want to cut the hard cases free because that's the way I roll. If I, assuming that
And so what they said is they need it in the order. to say-
Jacoby's case is going to go on
No, no,
Monday.
like, not explicitly, and then they'll take it off, because it was
I would
already
like it
taken
on.
off back in
I don't know
2000.
anything about it.
So, but they put it on because they was looking at this original bond. I know it's superfluous, but.
What have I done to my hair?
They need, you understand what I'm saying?
Hey, Mr. Green,
I don't know why they did it, but they did it.
All
how are
right.
you today?
No problem. Good seeing you.
Okay, this is 20 SC 174-520, Quayshawn Green. He's present in the courtroom with his attorney, Ms. Jones. Go ahead, Ms. Jones.
Thank you, Your Honor. This was on for case management, as indicated already at the calendar call. This 20 SC 174-520 case should have been null pros, and it should have been null pros a long time ago. He was re-indicted under 20 SC 177-025. We argued motions in August that are still pending. The state has filed a 418 motion, which is related to the introduction of potential gang activity. We also still have the press that is still pending. My understanding is this is set for a status update on 10/26/2023, along with his other co-defendants. I'm not sure if Your Honor is going to want to have that date as a motions calendar, but we will be ready to proceed on that. And my client will reiterate his that's the word I'm looking for, his insistence to be set on the next available trial calendar. Which is one of the motions we argued in August to sever and go forward on his own. I will note, as the date of this calendar was printed, he's been in 1,394 days.
And when do we have them scheduled?
10/26, Your Honor, for case management. But we would request just to be placed again on the next available trial calendar.
All right. We will, No, we're not talking about removing her. There's a chance that we may be scheduling a trial. Mr. Clark's defended on that day. But we've got some motions to get back to you on. And obviously 1,000 days is a long time to be in jail, and we will get this scheduled for trial as soon as possible. Okay? All right.
Thank you, Your Honor.
All right.
What do we do next, sir?
I think that's it until we can get Lee up here.
Okay, so we're gonna get Lee while judges on his break.
I mean, there's no way that I can, while you're moving people, there's no way that I can do Smith, right? That's what I thought. Okay. Keep Smith up here.
No, he was saying, while we go get Lee, they gotta choose deputies. Yeah, that's, no. So you wanna do it before we go down and get Lee?
Does that mean you're gonna be done at that point?
I have a case, Michael Smith, that's set for 1 p.m.
All right, let's go ahead and switch him out so we can get this bond thing done.
So you, which one is?
Keep Smith up, but make room for Lee.
Okay.
I have one.
Would you have something for 1? Motion.
No, just that is for trial on Saturday. I don't
But
know
they're
why there's so-
continuing that.
I'm guessing. they're not.
This is getting.
Is that mandatory? We reduced it. Yeah, I think I said no cost down. Robbery, guilty, guilty.
Let's just go for affirmative defense.
Line of contact.
That's what-
Mentally now, follow recommendation.
Yeah.
No drugs and alcohol. What about employment on this one since he's going to jail?
Not gonna come back and stay here 10.
I have, I can't guarantee what's gonna happen on that case, but it is my position that I have to talk to mom. I can't lean one way or the other. I think that if mom moves on this, here's what we did on this, she may be open, but she was matter of fact, she's like, he did it, he needs some paperwork. I said, okay, I let him know.
I think based on my conversation with her, I know you're not young, but it sounds like she's gonna be on board with something.
But he's gonna get more on that case, this case. Yeah, time. I don't know how, it's not gonna be 10 years, don't get me wrong. He has to get some time on the case because based on her position. But it will be served concurrent with this. It'll probably come out the same way. He's already served with 3 years. He'll get credit for that, and we'll just move serve concurrent. He'll probably get maybe a year or 2 more. That's it.
Are you gonna be asking for quite a bit more? Because I know that you want to do more probation.
I can do that, Dan. I can do that. So
And we make it like a total of
don't write this in stone now.
I
I have to
know.
get approval now. I don't want you to say, Bridget, you set me up. No, I did not set you up. I said I gotta get approved.
I know, I know.
Because what I want to do and what they want to do is 2 different things.
But I know he'd be willing to do it.
Yeah.
Instead of a 10, but 15.
Because I literally went in there, what I said was, look, this girl, excuse my French, is a bitch. And I don't want to be with her on the stage. She's very adversarial and all that good stuff. And, if she don't want to prosecute, why the hell we prosecute? So that's how I got that.
All right, and then on Miss Young.
Young seems like we should do an eval on Young.
I talked with her.
So why?
She's got drug issues, and I'm sure some.
And then, what about finding a place to live? Because she's homeless.
We have been going through that route. Set up a program and everything. Women on the Rise was gonna help her find a place to stay, but she's got this hold in the county. They were never gonna post, they weren't gonna post her bond. That's what we were talking about having happen. But once this hold in the cab for this felony charge popped up, they were like, no, we're not gonna do that, obviously, right? Because we don't know what you're getting at. So if she's connected with services, the question is what? It's out.
And what's going on with the case in the camp?
It's pre-indictment still, as far as I know.
But she's gonna be transferred over there.
Yeah, I mean, either she's going there or you see. So everybody else come up on much of this. But they've got a hold on her. She's not on.
Boomer.
Unless it's a 90-day situation and the cab when she gets there, it's whereas if they set her bond, because her record is such that. Yeah. Yeah.
Did you need to see Mr. Bonner?
No. He can go back down, yeah.
Mr. Barner can go down? See if she'll do 10 to 8.
Do 8.
10 to 8.
I'll let her. I'll see what she said about it. Okay. Can I get back and see them, or y'all?
No, you can go back. Council already back.
Yes. We're done, please. Thank you. I'm sorry.
I'd like this place.
Well, in that case, judge is taking a break.
I would put out
Go ahead and give
possibly
me
maybe 2 rooms.
I don't know when he's coming back.
Don't need
How are you?
Here's her.
Should give me his name. What's up, Sean?
Okay,
all right, cool. That's fine. And then I'll just say that, I'm looking forward to doing what you guys.
Are you trying to argue? Okay, sounds good. Well, we will catch up next week. Sorry to be rushing.
Oh, no, I appreciate it. I've been jumping from courtroom to courtroom. This is Shaq. He's my babysitter. He's down in trouble.
Are you sick?
Don't gas shame me.
That's funny.
No, we're not playing up here.
No, I know. Yeah, he ain't. It's not gonna go down. It's negative twice. Never give me that up. I would like my clients to. That wasn't cash only. No. You don't want cash only.
I was gonna ask for, I'm gonna be straight up, I was
All right, I'm just gonna stay here until. Is that cash only you want, or you wanna go to the bond? Yeah.
Are they gonna go to the bonding?
Okay, I just caught that I put cash on in there for some reason.
Okay, no.
Yeah, okay.
Come on, Shaq.
Roger, could you look at your email? I think
It is. If I can read it, I'm good.
it's the Lincoln lawyer.
He's with the deputy.
Friday guy.
Who, us?
No.
No, except the Lincoln lawyer was the one that owns these expensive cars and everything.
It's still.
He's the one with all the.
No. He drives.
Yeah, they don't know how we operate.
Let's go.
Good, okay, thank you.
Um. What's going on? If I need, I'm just gonna be right out there. That's fine. Yell my name, give me the bat signal. No problem, man. Check. Oh, yo. What's up, man? Yeah. Yeah.
Did you hear me on, Ms. Kirk? If you could just share that with me rather than download, I tried to download it several times.
I didn't know I sent you so much everything. I thought it said that it already, you know, if anything, it's the same thing. It's nothing new. It's probably the same thing you had already.
Well, I can't, no, it probably has the body cams.
The body cams. Okay.
And those are always important.
Okay. Now, what do you want?
I'll show you. Hold on. Oh,
Because I usually
so
write
you sent
myself
it to
a,
me like this.
yeah, I usually send myself a note and you
Download.
can't
I
download.
cannot download it, but if you share it with
Your
me.
computer don't have that much download. And the problem is that I don't know how to share it with you, so I have to ask the
Your
administrator.
administrator will be able to do it.
Yeah, I have to ask her how to do
Perfect.
that.
No worries. I mean,
Because they taught me that trick, and so that's why I've been rolling with it.
And I've been trying to explain that to folks, like, we don't have the capacity.
Wow.
Our computers don't, and we're supposed to have it on our H drive, which is supposed to be a quote unquote cloud. But I can't do it. And it's the same thing with that Chapman. We had Willie Holmes today. And she talked. And I told Ms. Clark about that earlier too, like, I cannot download it. You have to share it with me on evidence. Even though I prefer the download, because on evidence, and I don't know if you guys have this problem, but if there's like 100 pictures, you literally have to click through each and every one.
Yeah.
Rather than when if it's downloaded, you can just, you know, have a, what do you call that, slideshow? We'll talk. I just need to see what's going on. Because I think Ms. Clark previously offered like a 10 to do. On her. But hey, she is.
Client certified. You don't have any client second plea, or do you?
No, to plea today?
Yeah. You're a Braves fan?
Of course.
Of course.
So you watched the game yesterday?
Mm-hmm.
Did they win yesterday?
No, it was 10-2.
Darn. What they doing?
What?
She said, who won?
You don't follow the Braves? Look at me in my crazy face. Hey. They needed to take Bryce
Summer.
Elder out after the second.
You come from 1 o'clock or early?
No, I'm coming from a plea, I was told.
Okay.
Oh, Miss Big Balls. I'm not sure who is it.
I don't think it's mine.
No, it's, FedEx.
No, it's
Okay.
Clark.
What? Yeah.
I just have court at 1.
It's
so
at 1
very
o'clock,
sad.
so I come back? No.
Yeah, that was a sad game. I was so excited though after the second.
Because
when,
anytime a team scores 10 points in baseball, that means that means your team got beat down.
Did you
Because
watch the
baseball,
game?
no, I didn't, but I'm just saying, I've watched baseball before, and it's a slow paced game.
No, well, I mean, with the pitching clock, it's sped it up a little bit, but so Bryce Holder did well.
And they gotta win today.
I know.
Yeah, so.
I know.
They
I've got tickets for Saturday's game.
What happens if they lose?
They're done.
No, what was your tickets? I mean, that's what I'm saying. What happens with your ticket?
Just refunded.
Okay.
They shouldn't have let him pitch in the third.
I can only imagine the fans. I've been to like 3 of the games.
And I hate that Harper. Hate Philly. I hate Harper.
You never went in person to the game? Oh, no, you
Yeah,
got tickets.
we have partial season tickets to the Braves, so I think it's like 26 games.
Yeah, they played Phillies yesterday. Lost to Philly.
Well, you know, the Dodgers got bounced, which is crazy.
Yeah, baseball can be a little unpredictable. That other game though, they could have lost. They came back, luckily.
Well, you mean the Braves?
Yeah.
The Harris catch was amazing. I mean, absolutely stunning. And he tried to pull it off last night and didn't go as well. Unfortunately. It is what it is. But then the Hawks are gonna be starting up. I don't know if y'all are Hawks fans, but
That's this month.
Yeah, that's just one.
I don't think anything's gonna change with them. But yeah, that's this month.
well, I've been disappointed as well.
Yeah, and you continue to be disappointed. Something about Atlanta and their professional sports team, other than the Braves and the hockey team, they suck.
But the hockey team don't exist no more.
Not the hockey team, I mean the soccer team.
Oh,
Yeah,
yeah,
Atlanta.
Atlanta.
The Thrashers, see, I still remember the Atlanta Thrashers.
I do too.
And
They're in
you even
Winnipeg
go to
now.
those games?
Yeah,
Oh, yeah.
I went to a couple of them,
Uh,
yeah.
Why'd they get rid of them?
Wasn't making the money,
What? It's not a sport.
which is
Like a popular
interesting.
sport in itself.
You now have hockey in Las Vegas. I like, damn,
Vegas.
hot as it is.
And they're good.
Yeah, they're good. They won a championship.
Well,
last
that's
year.
because they're an expansion team and they got to pick players from each team. So
Yeah,
of
but
course they're gonna.
that expansion was back in what, 2010 or something, was it? A while back.
I don't think it was that.
But it's been a while since that expansion team. So they built what they have now.
I'm a Calgary Flames fan, but they are talking about another expansion, or we might get Arizona. We'll see. But I'm not driving to Forsyth for hockey. I'm just gonna tell you that right now. Too far. But I'm also a Falcon fan, so
You're just doomed.
I am.
You are just doomed.
Yeah. But I'll be watching the Braves next. The games. I mean, I even left work a little early so I could get to the game on TV at like, started at 5:07, but I didn't start watching at 5:30. And I was just.
Looking patient, man.
Good.
So did you ever do conflict work?
That's what I did the last 5 years before I came here.
Were you part of the conflict office? Okay, okay. So I feel like I remember you in La Grua.
It's been much time in the group. Yeah, I don't even remember having a case in the group. Yeah.
You were a C3.
Yes, you can.
Oof. See, I always feel bad for the C3s. They went through the public
You
defender's
don't watch-
office.
you
They
don't
went
watch-
through
you watch
conflict.
tennis?
What?
Tennis,
No.
rugby? What about NASCAR?
Mm-mm.
I'd be surprised if you said that.
I'm gonna prison.
I've been to a Formula One race though.
That's fun.
Yeah, the first year they did it in Austin.
And believe it.
That is
Very
too much.
interesting. I
You
went
know, I
to
wouldn't mind
Daytona.
going.
You
It
don't
was-
think that.
I went to school in Daytona, so I
Okay.
was always at the Daytona.
It's
It's intense.
That is huge.
Them cars be going by 200 miles per hour plus, it shakes the whole,
Oh, I'm sure.
it was 2017.
Oh, okay.
Yeah, they went there,
Yeah, so players still got 5 years. Yeah.
No question, they cycled that team out.
I want to say the Formula One though we went to was probably 2012, 2013. Because we lived in Oklahoma at the time. And it's crazy how that is such a rich person sport. There's just helicopters coming in.
They all done one? What's the last one? All right, so when he come out, we can check him down. Oh, no, I have shoes, but these ain't comfortable. I'll wear my shoes.
Yeah, I don't care. We have a lot, so they aren't gonna be deals.
I'm the new stepchild. Apparently. If, I think they say if there's a problem, send Roger there. I think that's the motto now.
It's not a problem.
No.
You have a hot case. Yeah, that's the problem.
That's why
Bring it
we
out,
have-
it's gonna close the cases
Just gonna
out.
close the cases. Those are my instructions.
Fire sale, you can buy one, get one free. Go, go, 50% off.
How many times have y'all asked me for something? I said, let me see what I can do.
Oh, that's what I did. I was gonna take shopping.
Is Shama back today?
No, she's at home still. She's still unwell.
Yeah, she was on the Zoom.
She was on the Zoom?
It is.
Okay, cool. I'm going to,
What you gotta do.
1 o'clock.
I said, what you gotta do.
Yeah.
Hopefully I won't be here 1 o'clock when you get here.
Why not?
I'll be done. And that's always good. I said, you go first?
I just want to take care of it.
Okay, well, I don't know what's on that 1 o'clock calendar. What's on that 1 o'clock?
I know I've got a plea and then I've got a murder status update. But I've,
Trial?
I think Satterwhite's going to trial. I guess mine is just, I've just got false information. So when they came to either arrest or Satterwhite, I think it was an arrest. My client was like, it's scary. I don't know. And so they arrested him for if you knew my client, he's like probably 18, 17, probably hanging out in his room. I mean, he didn't know and didn't care. Step, I mean, stupid. Maybe they'll cut us loose. Please are just mad. It is.
Just thinking like, yeah, why are you still here? Yeah, okay.
Yeah, so I might sit on a murder trial for misdemeanor.
Are you gonna talk to the attorney? You're just being nosy.
But the funny thing about it is John.
Just say it, just say it.
John and I had this in Magrua and we put him in My Journey Matters. Cause this kid, if you knew him, it's like, this makes total sense and you would just be like oblivious. Then COVID hit, the girl got promoted
So.
and everything, you know, he just kind of, yeah, just. went-
That is the past.
Yeah, and now he's back and I was like, see now, John, you understand what I'm saying? Like kids oblivious, like, yeah, I get it. Oh, but I know he gave an offer to Satterwhite, so we'll see maybe. I don't know anything about it other than my client.
file a motion to send it to the post.
Maybe I should have done that. I don't know.
It's completely, he's not the same person convicted based on the other guy's
No, and the thought process way back in the day, I mean, this is pre-COVID, that's a lot old this case is like have him for a year or whatever, and then move him on. Like get him back kind of on his feet, a little structure in his life, and that's because it was just shortly thereafter COVID hit. And we all remember COVID. I mean, it was supposed to be just 2 weeks. It's just crazy.
I knew we were in trouble before when Delta said they weren't going to China. I said, oh, dude, it's on. I didn't know how bad it was gonna be, but I said, when Delta give us up money, there's a problem.
Yeah, I didn't even
And that special guy y'all had in office just didn't understand the concept.
know. Well, I just remember too, when they wouldn't let that what do you call that? The boat dock, you know, the cruise boat. I was like, okay, that's weird. My kids were younger too, so I was just more focused on school.
I had a teenager at that time.
No, I mean, and we had Lagrua then too, and Lagrua, as you well may know, didn't like to take a day off. So she, we did a lot of Zoom early in the day.
I love those days.
And she would take everybody's dates and she would give us our caseload. She marked how much that these would go, let's move these cases. So it almost felt like we didn't have a day off in a way. But yeah, it was crazy.
Yeah, most of my cases, we try.
These were just what we call the low hanging fruit, you know, the repeat offenders that we get. Yeah, that's what I'm saying. Like, that's why I would hate to be a C3 because unless it's a co-defendant case, they've been through the system quite a bit.
Once
You burned
once
your two
COVID
offices.
ended and I started looking at those calendars, I said, "This is really possible."
Yes, I had my. It was a murder. Oh my gosh. Yeah. But I had him brought in it. This was actually when the jail was more or less safe. He jumped one of our clients.
Yeah, literally the second child. Second trial. Which their courtrooms. I don't know if you've been in. It's just a little place. Is cab is much more fancy. Yeah. This petition is really nice. This is really nice. I don't know how much the jury could hear us behind those things, but yeah, it was really nice. Lost that case, of course.
Sometimes cases are just slow.
That's a good one.
I think he's signing up. I'm just waiting till 1. I'm really disappointed that they've kind of scrapped the cafeteria.
Well, they have something in there now. Have an honor system,
Oh, yeah, but I mean,
They
used to,
downstairs.
yeah, and then they have a group that comes in, search function. Just like they used to have on the other side of.
I just remember they used to have Chick-fil-A, which I
Yeah,
liked,
that
and
I
then,
missed too.
you could get a hot dog, the hot dogs weren't bad. It was kind of an, I mean, it sounds weird, but hot dogs kind of light in a way, so if you were in trial, just. Mm-hmm. Yeah.
Make real breakfast, fresh eggs, bacon, sausage. Everything.
Oh, I bet.
So sweet and so nice. Yes, babe, what you want? Yes, please.
Good old days. Huh?
Oh, yes, absolutely. Absolutely. I mean, just absolutely fresh food. And then when you go across the street, you know what, we have take over there. They have a garden over there. They used to have, serve food. You can go sit outside in that garden, you go there.
Yeah. Well, they used to have a few good places around, but COVID just knocked them out. I do know there was one little sandwich shop that opened up, and I was still in Newcomb. I don't remember the name of it, but it wasn't very far away.
Like
They
American
closed.
Deli, but is, Rose's. And then we went down further. That little area that's empty now, there used to be a couple of restaurants. There was, Lattice Chicken and Waffles, and they're both real hot seconds. And then there was another little restaurant.
Sylvia's.
Breakfast and lunch. Sylvia's, yes. And there was something else, it was like a no name, but it was okay, but it was good for when you're walking down, trying to buy something. Then they had Kroger. Kroger,
Mm-mm.
so that new area where they have the Atlanta City spot, there used to be a Kroger.
Oh, I didn't know that.
Kroger shopping center, I mean, a full store, but I think they closed it down.
Sure. I didn't know, yeah, so I only began working downtown 28. So my first stint in Georgia, when we were here, we lived here from 07, 06 to December of 07, and then I worked up in Market, which is harder stuff. And that has changed. I mean, I am shocked at the growth that's happened up there.
But I never had to come downtown.
Okay. My commute's not too bad. I just gotta get on 75.
But you know, it's not as bad as 75. But I mean, on 25, where you do a rolling. It's just when you get to 20, it's just like, oh my God,
Yeah,
what's going on? It's either the sun or this,
I agree. That's a terrible, terrible.
yeah. So in the summertime, when it starts, when it goes from winter to summer, spring, and then from summer back to fall, that the sun, it hits at a certain spot. And if you don't have on shade, it's like you're blind. Yeah. Well, John, you okay? You want anything?
Is you gonna take that plea before what?
Whenever that attorney comes back, and then they have to take people down, and they're gonna bring the rest of everybody else up. Bye-bye. Oh. I don't wanna give you a definite.
Yeah, I'm just gonna go hang out at the.
Who you waiting for?
Oh, Catavius Fines? I didn't, he's my co-defendant for Mr. Green. He'll be set for 10/26.
Oh, that's right, you got a moment. So we're still holding for the attorney. I
I'll
don't-
put it on speaker.
Hey, how are you? Say that again? For. Yeah. You talking about for roads and buying?
Rhodes is also.
She's talking about. Oh, okay, so basically what happened, like, you know, we had. Oh, I thought you were.
She's asking about.
Oh, which one is she?
Mr. Vines.
Well, Mr. Wilson for, there was a 418 motion and he asked for 8th Amendment motion. Yeah. And so these two I had this earlier. These two were like, oh, we can't do it on that day. Can we set it for a later date? I said, okay, here's the date, and neither one of them are here. So I was like, well, you know.
I'm sorry, Miss Robinson, this is Ocon, but I think they are also set on the 26th. That's what's causing confusion. The rest of the co-defendants are set on the 26th with Miss Jones's client. So we're all back on the 26th. And so I guess that's causing confusion, but the remaining 3 people are on the 26th.
Yeah, they should all be set on the 26th, I think.
I know, that's why I'm confused. That's why I'm calling to check to make sure we're all on the same page. Because they're on the 26th. I think everybody thinks it's the 26th.
It's working. It's working.
No, I can't. Sorry.
So I
Oh,
put them
thank you.
on this one because when I set them for the other dates, the attorneys were like, oh, well, we've got leave or we've got something else. And I was like, okay, well, how about this date? They said it's fine. So I put them on these two on this date.
Yeah, because I think they are also adding to, I don't know. I mean,
and
I'm
that's
here
fine.
because
If
I was
they-
told to be here.
Yeah, and we can, yeah, they'll all be here on the 26th. So, you know, if the judge says that we're gonna hold it till the 26th, that's more than fine with me.
Okay, I'll stick around for that then. Thank you. I appreciate it.
All right then.
Sorry, I couldn't hear you before.
Okay, sweetie.
It's gonna be the 26th. I mean, well, date on that date. So for whatever reason, the co-defendants actually split.
And then I put on.
My client is on. But it's just gonna be.
Thank you.
Well, I know my client. I don't know, I can't speak to Mr. Wilson. I can't speak to the co-defendant.
No,
I
they
have
haven't brought her up.
So he's my client,
Oh,
they're
they
co-defendants.
do all this
But
stuff
it's gonna be
there.
the 26th, case management is requested. That's all I know.
Oh, Ms. Jones, it's emotions, right? I know it says case management, but it's emotions because I'm subpoenaing everybody for the motions just so that we're on the same page.
I mean, I'm gonna prepare for motions to be heard on that particular day, but. you
Okay,
know,
because I'm
that's
gonna have
always-
Leon Packer come just so that we don't have to come
I
back.
mean, but it's always the pleasure of the court, right?
I'll subpoena him just so that we don't, you know, I
Because
will.
I don't know if any of the co-defendants have really filed anything yet.
I would just bring him, you know, let's be safe, then sorry.
Yeah, that's all I'm saying. I'm going to be ready. If the court wants to set it off to another date, that's fine. It is what it is.
Okay.
But we'll be ready.
I'll
And
have
we'll
him
talk,
subpoenaed today.
Of course. I know where to
Okay.
find you. I know where to find you.
Okay, thank you.
No worries.
Okay, so it's
10:26, yes.
And on the 30th, I'm supposed to try a case.
Right. I'm just gonna go hang out and. pee. I got one o'clock.
I mean, if that's, I understand that, just, I'll see. Did he say when he's getting back on the bench? That's it for us to trial. Stefan's proof. What's wrong? He's probably not. Especially if.
Do we have anything else in that trial?
I don't think we have anything else, but. This feels like yesterday. The only other cases that come. He continued bail, yeah.
That's almost 20-some years.
Yeah.
Well, not 20 years. Yeah. Couple years with the probation, PD's office. Couple of years.
Claudia, sorry.
Hmm?
Claudia, sorry about that.
No. I was over there.
The prosecutor.
I was in the court school.
Okay. Okay, that's cool. I used to be the Chatham County Public Defender's Office. The intern that they have at the juvenile court. Linda Pace, I think. Oh, from New York, but when I came out in the recession.
Oh, yeah.
I applied to, if they had 48 public defenders office, I applied to 40. They said emailing me like, why do you want to work in Dublin, Georgia? They went, it's all right.
I like the business event.
And visiting is different. You go on St. Patty's Day, it's all turned up and it's nice, but it's not like that. It is New Orleans. It is New Orleans. It is New Orleans.
Without the smell and the population.
Bennett is come on vacation, leave on probation. That is Georgia, but it's worse over there. It is Georgia. You know, they said that we're number one in the country for people on probation. The fifth in prison, but number one on lengthiest sentences on probation.
Yeah, you want to talk to him?
Please. Let me get my, hold on, let me get my.
Exactly.
Yeah, because I just gotta.
Looking for your phone?
No.
Thankfully not. You come back talk to her again? No. Promise to know that we're ready for. Well, she's not coming out to the judge coming out. The judge is probably once now. All right. I'm just letting you know. You stuck, bro.
Yeah, I'll be trying to get out.
Look, hey, well, I'm supposed to keep you the buck, am I?
What time you think you coming back? Like, can I go to lunch or no? That's what I've been trying to figure out.
What time you come back out?
He usually go from 12 to 1.
All right, I'm gonna be back 12:30.
Stand by, let me go check though. Don't
Okay.
go yet, cause
Okay. That's what I'm saying. I go first.
Yes. We're doing your case.
Oh,
Is that
okay.
what
He's
you would
coming
like
out.
to ask?
Yeah, I didn't know if this was at lunch. If I.
No, it's not at lunch. We're doing your case. We're waiting for
Yeah.
the people to be brought up. And we're
that's
gonna
why I
do
told
your
you to
case.
stand by so I can go back.
Okay, good.
He would let y'all know. if it's lunch.
Yeah.
Okay, no, good. I'm glad I didn't.
You all right? I told you not to leave though.
I appreciate you.
You rolling?
Listen, you left. That
No.
was it. I would've re-stepped in.
No.
And go home. This is just a lot.
Yeah, we just, so basically on the CP case, there were 4 charges.
I'm
When
going
they
to
indicted,
rush on
they had
this guy.
2 more charges, so they won't release.
Oh, so they just need to put them out on the. Is that all?
Judge one.
Wow.
Yep, so push them out.
I saw you, but did not.
You know, we may go to on Clark Speedy, we may schedule that on a 26 and just roll with it. I forget his client. I don't know. Yeah. Hey,
Yeah.
sure.
Yeah, I said already.
Okay.
You want to bring out Lee? Okay. All right. Okay, this is 23 SC 152 Aubrey Nicole Lee, who's joined by her attorney, Brandon Alexander Thomas. They're both present in the courtroom. And we have Mr. Bridges with the state. And Mr. Thomas, there's an issue with the bond, right?
Yes, Your Honor. My understanding is that the charges in the indictment are different than the initial charges that I believe was arrested on. And so they've added some additional charges. And so in light of that, we would ask for a low bond because RB Lee already paid a bond of $38,000 in 2020. They've been out on bond all of this time. There's been no issues. And so basically, we would ask for, under the circumstances, a $5,000 bond to cover all charges, given that nothing new has happened. It's just they've added new charges.
And so what are the additional charges? Is it 2 aggravated assaults or what?
Yes, Your Honor. And initially,
So counts 2 and 3 on the new indictment. Are those the new charges?
yes, I'm looking at the original bond. The initial charge was aggravated assault, simple battery, reckless conduct, obstruction.
Yeah.
And then in the new indictment, I believe we have 3 counts of aggravated assault
Okay.
in lieu of like the simple battery. Please correct me if I'm wrong. Okay, so basically they changed the simple battery to ag assault, which they have a right to do. The prosecutor can
Sure.
change the charges, but you know, given the circumstances and nothing new has happened, we would ask for a $5,000 bond. They don't have, he doesn't have much money, and this is of course not the court's fault, but just to color the situation a bit. Her family has been here in Atlanta for the last 2 days, staying in a hotel because they thought they were getting out a couple of days ago. That's not the court's fault, but they're spending money on that. And so they don't have that much money to be bonding out, or release. So that's why I would ask for a low bond.
Mr. Bridges,
Your Honor, Mr.
if you could speak into the mic, maybe the mic's off. I don't know.
I'm sorry.
That's right.
So Mr. Lee has 2 cases. On the second case, I do see where he did post a $38,000 bond back in 2020. But the, I'm sorry, did I say the wrong date? Yes, I'm sorry. The CP case, he posted. Subsequently, the case was indicted. Then we had the FTA due to the attorney's fault. The company has since then come off this case, so it means he has no bond on the case at this current time. So I just asked you set a reasonable bond with the with conditions that we have agreed to, and whatever the court sets, I'll fill out the bond motion and send it to Miss Kathy, so you can be completed.
So we need a bond on the other case too, then?
I didn't know there was I didn't know there was an issue with the other case.
Well, I don't think there is, but it this hadn't happened to me before, Your Honor, but it, basically, the case is so old, it's from 2020. After 2 years, the bonding company filed a motion to get off, the court granted it. I don't believe that would cause, so technically they don't have a bond on that case.
But he's not being held on that.
He's not being held on that. I guess I'm hoping we don't have to come back and that we're done here, so.
Yeah, I can't post a bond in a case it's not, that doesn't require bond, so.
Right.
that's
So we
just
should be
bond
fine. We should be fine then. We should be fine.
Okay.
But we would ask for a $5,000 bond on this case for the new charges since they already bonded out in 38,000.
But I'm still, unless I'm wrong, Mr. Bridges, I mean, whether it's whatever I do hypothetically, it would be bond for each one of these charges, right? It wouldn't be the additional ones because.
Your Honor, in essence, we're having a new bond hearing on the indictment. As though it's first time before the court.
And why again, I should remember this, but why again did Lee? Why was there a failure to appear?
So, Your Honor,
That's right. Previous attorney.
previous attorney didn't change his address.
Okay.
And Aubrey Lee was relying on them to tell him the court date.
Yeah, that's right. We talked and Aubrey Lee, I mean, I get that part of the why you hire an attorney is to keep up with this, but you need to keep up with your address as well. And we talked about this.
So that caused a major trust issue with the attorney. That's why I'm the new attorney.
Was it 5 charges?
Six, Your Honor.
6, Your Honor.
So we have aggravated assault, obstruction, simple battery, and reckless conduct.
Your Honor, would you like a copy of the indictment?
Yeah, no. But the problem is that if I do the original bond amount, he's gonna have to repost that. I think.
That's correct.
It's a brand new bond hearing. The old bond hearing is irrelevant.
Correct, Your Honor.
All right, so what I'm gonna do, there's been no, other than the failure to appear, there's been no other issues, right?
Yeah,
All right.
the other case happened before this case, Your Honor.
All right. With the previous conditions in place, I'll do a $6,000 bond, $1,000 for each charge.
Thank you, Your Honor. Can we, I think the process.
And you said you'll write up that order?
I've already written it up, Your
Okay,
Honor. I'm just
all right,
waiting-
thank
just
you.
Waiting on your numbers.
All right, thank you.
Okay, 6,000, 1,000 each charge?
Yes.
Thank you, Your Honor.
Is that it?
That's all,
Same
Your Honor.
conditions as was on his previous bond.
Same conditions, except just one thing that the jail said that they need this language that that no leg monitor is being required. I don't know why they put it on. The court's order before didn't tell them to put it on, but they put it on, and so they need so just letting the court know that we're gonna put that in the order. Because in 2021, Judge Rickman had taken off the leg monitor.
I mean, this is a new bond order. This is all brand new, but if you want us to, we'll put no.
Unfortunately, I
All
don't
right,
know
sure.
why the judge, but
I see Mr. Bridges.
So the bond, the sheriff's office is looking at the original bond conditions, and the part of the original bond conditions on the original bond was that he have an ankle monitor and 24-hour curfew. We're taking that off. We're not putting that in the new bond order.
Yeah.
I mean, he's been okay for 2 years, so I don't see the reason to, unless the court sees a reason, I don't see a reason. to do
No,
that.
I don't either.
All right, thank you very
Okay.
much, Ron.
All right, you're excused.
Thank you. All right, that's it. Y'all have a good afternoon.
All right, I see Mr. Shart. So let's do Vincent Williams. Good afternoon. Position 4. Is your client present? Okay. Are they getting him?
Yes.
All right. Were you down at YSL?
Yes, we kind of zoomed through jurors today, so we are done. for
You
today.
picked a jury?
No,
For today.
Yes,
For today.
I don't want to start any rumors.
That one would be a big one.
Actually done for the week.
Yeah, all right.
Vincent Williams. No, it's gonna be further notice, essentially. Vincent Williams, yes,
Well, there's a mental health,
non-COVID.
there's a mental health evaluation involved in this.
There is, and
Alright.
it's come back, and he is competent.
Is he the one that, the older guy?
No.
Oh.
Young guy with tats.
We got a guy back there. He's definitely mental. I don't know his name, but he's probably, you don't know when he come out.
Yeah, I think I had him. Vincent Williams.
Vincent Williams.
And Your Honor, when Mr. Williams comes out, I would like to just kind of address where we are with the case.
Sure,
Just because he's been in there so long, I want.
I get it.
I'm doing everything now.
I can pull up my emails. I'll say 2 months ago.
Council stuff right here.
Okay, this is 21 SC 180033 Vincent Williams. And he is present in the courtroom with his attorney Maxwell Shart. And we have Mr. Bridges, who's on behalf of Ms. Marsh, correct, Mr. Bridges?
Yes, Your Honor.
With the state. Go ahead, Mr. Shart.
So thank you, Your Honor. May it please court. And I'll just point out that Mr. Williams is supported here by his auntie and his father as well. Mr. Williams, as Your Honor knows, has been incarcerated for years at this point. I was appointed through the county program. I think he had already been incarcerated for approximately 2 years by the time I was appointed. We had a bond hearing. I don't know if Your Honor recalls, he was denied bond and it was agreed that there were some competency issues that needed to be addressed after that bond hearing. He was also scheduled for arraignment. I do not believe, and I could be wrong, I do not believe he was arraigned because we held it off due to the competency issues. I have received a report back from the state doctors. They have found him to be competent. I think that there is a need, and I've reached out to the restoration pod at the jail. Typically, they are in charge of restoring people to competency without the need of sending people to Georgia Regional. But when there's certain mental health issues, I've been told that they also consider allowing people onto the restoration pod just for monitoring to make sure that mental health issues are being addressed and to make sure people remain competent. Mr. Williams, I've spoken to him today and he is 100% lucid and cooperative, and that makes me very happy and that's awesome. But that's, in my experience in prior dealings, that hasn't always been the case. And it's not about me. It's just if this case went to trial, I would want to make sure that Mr. Williams does not act in a way that would submarine his own case. Because factually, I think he has a very defensible case, but I need him to be with me competency-wise to ensure that he gives himself a fair chance. All that being said, I reached out to ADA Marsh, I believe, probably 2 weeks ago, once I realized that she was the ADA handling the case now. We've exchanged emails. She has informed me that she plans on meeting with the alleged victim next week, assuming that the alleged victim keeps the meeting time. There's mental health issues on that end as well. This alleged incident allegedly occurred in the bathroom at the psych ward at Grady. So assuming that meeting comes to be, I believe that the state is going to convey an offer that they feel is appropriate in the next week or two. I have informed Mr. Williams and his family of this. I don't know what that offer will be, but I will certainly convey it once I receive it. And there is a possibility, I believe, that this case may be resolved short of trial. Hope is eternal. And we will, and as soon as I know further information about the offer and what Mr. Williams has to say about the offer, I will certainly inform the court to let Your Honor know where we stand. It's not lost on me how long Mr. Williams has been in Rice Street. Or he's now in Union City Jail.
So what would you like to do with this case?
I think right now we need to just, we know what we're charged with. We're willing to waive formal arraignment. We're pleading not guilty. I have received all of the discovery. And I would like to either informally report back to the court as soon as I hear from the state and I'm able to speak to Mr. Williams about an offer, or we could set another court date. Your Honor knows I'm in trial, but I'm in this
I don't mean
court.
to interrupt you, but can you print out some paperwork for the plea and arraignment?
Okay. Okay. And yeah.
All right.
And what I was going to say is, as far as all the pretrial things and negotiations,
sure,
I'm very able to find time to do that and file any motions. I'm constantly working on other cases. It's just, quite frankly, the only thing that I'm not able to do as I'm currently on trial is strike a jury and try another case.
What about like a status in 60 days, just so it doesn't slip through?
That's absolutely great. I would love to do that. And Your Honor, we could even do it sooner if Your Honor would like.
Well, I'm saying as a backstop, if you come up with something
Absolutely.
before that, reach out.
Okay.
So we'll put
absolutely.
down a status in 60 days unless you reach out.
Absolutely.
Okay.
That sounds great. Does that sound good to you?
Yes, sir.
All right.
All right, excellent.
Okay, you're excused. All right. You want to do those, please? What? All right, bring out Shaquan Smith.
Good afternoon, Your Honor. This is ADO Com. I was wondering for Mr. Bynes and Mr. Rhodes, should I still stick around or have we been reset till October 26th? Because I think the co-defendants are set on the 26th and none of the attorneys showed up, Mr. Wilson or Miss Bumpus.
Who asked for it? What positions are these?
They're on the motion.
There's 1 and 2.
This is 181284. 181284.
181. 181.
284.
Eighth Amendment motion.
So the attorneys asked for this, but they didn't show up.
Yes, Judge, and I've been waiting since 9:30. Can I be excused?
I mean, you know, I was gonna excuse you anyway before the sad story, Miss Oakham, but no, I mean, what can I say? I mean, you know, they didn't show up. You're excused. We'll address it on the 26th. Let's schedule them on the 26th, okay?
Thank you so much, Judge. You
Bye.
have a good day.
You too. No. Yeah, you can tell them their attorneys didn't show. So they're not all mad at. Well, I mean, 1 minute. All right. That's the way it goes. So this is 22 SC 181284 Shaquan Smith, who's present in the court with his attorney, Mr. Philip Clark. And we have Mr. Roderick Bridges with the state. And you have a negotiated plea to present?
Raise your right hand for me. You swear that the testimony that's about to give the court the truth, the whole nothing but the truth, so help you God.
Yes, sir.
How long has Mr. Smith been in jail for?
He's been in since December, early December of 2020, Your Honor. So we're right at about to be at 3 years in another month.
So that's why he was teed up number one on the consolidated.
I would imagine so.
Because they go by jail time. Yeah, they go by jail time. Thank you for that. And then the state is working with you to try to resolve the other indictment.
That's correct. We've been in touch, and I did want to address, I guess, just mechanically what I would ask the court can happen after the plea in this, because I don't want Mr. Smith. This is going to be it's not a commuted to time served sentence. It's going to be a time sentence, and I would prefer that he not be shipped off to the state system and then have to be brought back for that other. But I can get into that at the appropriate time,
Sure,
Your Honor.
sure.
Mr. Smith, can you state your true and correct legal name?
Shaquan Smith.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, sir.
Is there a medication that you normally take that you have not been given today?
No, sir. No, sir.
How old are you and how far did you go in school?
29, completed the 12th grade.
Are you able to read, write, and understand the charges against you?
Yes, sir.
Do you understand that you've been charged with the following offenses? Home invasion in the first degree, armed robbery, aggravated assault with a deadly weapon, possession of firearm during the commission of a felony, simple battery, cruel to children in third degree, criminal trespass, and possession of firearm by a convicted felon.
Yes, sir.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including potential defenses?
Yes, sir.
Do you need more time to discuss the case with your attorney?
Oh, yes, yes, sir.
And he just had a question about the charges, and we'll get to what the actual plea offer in this case is. So, yes. Do you need any more time, Mr. Smith? Just say no.
So,
No,
Mr.
sir.
Smith, do you need more time to discuss the case with your attorney?
No, sir.
Are you satisfied with your attorney's representation?
Yes, sir.
Do you waive formal reading of the indictment?
Yes, we do.
Do you waive any and all defects?
We do.
The state is unaware of any outstanding warrants related to these charges. Do you or your attorney know of any outstanding warrants that relate to these charges?
We did not.
Mr. Smith, do you understand that this is a negotiated plea of guilty, which means that the state will make a recommendation to the court that you plead to count one is going to be no pros, count two is going to be reduced to robbery, and the sentence will be 10 years or serve 5 years. Count three will be aggravated assault with a deadly weapon, sentence would be 10 years to serve 5 years concurrent with count 2. Count 4 would be possession of firearm during the commission of felony. Sentence will be 5 years consecutive to count 2, which would be suspended. Count 5 will be simple battery, which would be 12 months, which will be served concurrent to count 2 and will be probation. Count 6 will be 12 months probation, served concurrent with count 2. Count 7, cruelty to children in 3rd degree, will be 1 year probation, served concurrent with count 2. Count 9 with criminal trespass be 12 months probation, served concurrent with count 2. And count 10 would be possession of firearm by a convicted felon, which will be 5 years consecutive to count 2, suspended. Do you understand that?
Yes, sir.
But the court does not have to accept our recommendation. The court can sentence you to the maximum on each charge and can run these sentences consecutively or one after the other. You understand that?
Yes.
You didn't speak up. I don't think she heard you.
Yes, sir.
You understand that this plea may be used to enhance sentencing on other charges, including jurisdictions as well as other jurisdictions, including the federal court.
Oh, yes, sir.
Do you understand that if you're currently on probation or parole, your probation or parole may be revoked based on entering a guilty plea today?
Yes.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation of the balance of the sentence?
Yes, sir.
Do you understand that you are not allowed to possess or use a firearm while on probation?
Yes, sir.
Are you currently a United States citizen?
Yes, sir.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial? For example, your guilty plea may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or your ability to get employment.
Yes, sir.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, sir.
Do you understand you waive any and all defenses, including any mental health defense, by entering a guilty plea today?
Yes, sir.
Do you understand that if you went to trial, you would have the right to a trial by jury, the right to see, hear, and confront witnesses called to testify against you? You would have the right to testify or remain silent and not incriminate yourself.
Yes, sir.
Do you understand by pleading guilty, you're giving up the following right: the right to a trial by jury, the right to remain silent, not incriminate yourself, the right to confront witnesses against you, the right to assistance of counsel hired by you or counsel appointed by the court if you cannot afford an attorney at trial of your case, the right to presumption of innocence, the right to testify on your own behalf and present other evidence, the right to subpoena witnesses and compel the production of evidence, the right to have the charges against you proven beyond a reasonable doubt, and the right to appeal if you're convicted of these charges at their trial.
Yes, sir.
Has anyone forced or threatened you or promised you anything to enter a plea today?
No, sir.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, sir.
How do you plead to the charges in indictment number 22 SC 1818, 22 SC 181284, the charge of robbery, charge of aggravated assault with a deadly weapon, possession of firearm during the commission of a felony, simple battery, cruelty to children in 3rd degree, criminal trespass, and possession of firearm by a convicted felon?
Plead guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, sir.
Do you understand that you may have only a limited right to appeal this guilty plea?
Yes, sir.
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file what we call a habeas corpus, challenging the constitutionality of the plea, and any motion to withdraw your guilty plea must be filed within the same term of court in which the judgment of the conviction is entered.
Yes, sir.
Your Honor, had this matter gone to trial, the state would have shown that on October the 16th, 2020, that Mr. Smith went to 185 Bear Run Court in Chattahoochee Hill, Fulton County. At that point in time, he kicked in the door of the residence of the victims of the house and assaulted the victim, which was his ex-girlfriend, by choking her and pointing a gun to her head, and was threatening her, saying that she could not leave him. During the altercation, her 8-year-old son was knocked down by the defendant in the altercation. Mr. Smith fled the location and was later arrested by officers of the Chattahoochee Police Department. That would have been the case, Your Honor, had this matter gone to trial.
All right, so I got a little tripped up when you were doing your sentences, because on the Odyssey, of course, there's 9 charges listed, but in the indictment, there's 10. I'm trying to figure out what.
That's not uncommon, Your Honor, when they actually do the indictment, they add additional charges.
Why am I having so much trouble with this?
Let me look it up and I'll find it. Okay, so. There's 9 on an Odyssey too. Your Honor, can I borrow the indictment again?
Sure. Pardon me? Yeah, there's 10 on the indictment, though. That's what I'm trying to figure out.
The possession of.
The indictment skips 8, it goes 7, 9, 10.
Okay, all right, there, you figured it out.
Yes, I'm glad you did before I did.
Because I kept lining them up, and it's an optical illusion. It skips 8. Okay, well, I'll be darned. So
I forgot to tell you the conditions of probation. We are going to ask that he have a mental health evaluation and the following recommendation of treatment.
okay,
No violent contact with the victim in this case, which is Taylor Pitts,
okay,
or her son. Stay away from the incident location. I think that was it, right?
That was it, yeah.
That was it.
okay. Well, let's go over. So count 4, 5, 5 to serve suspended. That makes sense. Count 5, 12 months probation concurrent. 6 is 12 months probation concurrent. 7 is 1 year probation concurrent. Is that
Sorry,
correct?
7 is accrued to children in 3rd degree.
Yes.
That is 12 months probation to serve concurrent with count 2.
And then I got tripped up because it skips 8 and jumped to 9. So what was 9? That's the criminal trespass.
That's 12 months to serve. 12 months probation concurrent with count 2.
And then possession of the firearm.
That's 5 years consecutive suspended.
All right. Okay. All right, Mr. Smith, do you understand? And, oh, I'm sorry, we've got you. Now it's Mr. Clark. Go, Mr. Clark.
Yes, Your Honor. We're asking the court to accept the agreement. Mr. Smith has been in since December 4th, 2020 is the exact date of his arrest. We're asking the sentence itself reflect the credit for, he's entitled to the credit for time served on this, but
And what was the date?
December 4th of 2020.
All right.
December 3rd, I believe he was in custody and then was brought to Fulton County on December the 4th. So I'd ask December 3rd that he could be given credit for that date. Other than that, Your Honor, we're asking the court to accept it. At least in speaking with his family, it sounds like during this period of time, this case and the other case that's pending were within a month of each other, essentially a month and a half. And it sounded like there was some serious instability going on in Mr. Smith's life. The other alleged victim on the other case is his mother, who I've spoken to. She wants to see Mr. Smith get a mental health evaluation, suspects that he may have some untreated mental health issues. So that is a reason why this is a condition of the sentence. Your Honor, what I would ask is also the court to consider is, given that there is this other pending case outstanding, Mr. Smith wants to reach a resolution on that as well. And I do think it would be prudent to not have him be transported to the state system and then transported to have to expend resources to do that. So I guess my suggestion would be either, one, I would be asking for this to be set down at the earliest possible date. I know the court has calendars on the week of the 23rd. And speaking with Mr. Bridges, it seems like he may have some conflicts that week, but I would like this to be set down as quick as possible so we can reach a resolution on the other matter. And so I would ask either the court withhold, I guess maybe potentially signing the sentence or transmitting it over to the clerk's office until we have that second court date, or if the court's not willing to do that, to sign an order holding him in the Fulton County Jail until that other case is brought before Your Honor for a resolution, because I am optimistic in speaking with Mr. Bridges that we'll get that case resolved too. And we can, have both of them wrapped up. He can go to the state system with both cases resolved and await on whatever decision we make.
Your Honor,
How quickly can you?
I'm not available till November. I know I have a trial on the 24th right now and a trial on the 30th of October. That's
With
current.
who?
As I explained to everybody, I'm the current stepchild of the office. I get to go wherever they tell me to go. So I have the lingering gang cases I have to resolve, and I got
know.
assigned to other
Listen, I've
cases.
never had them tell me I've got a trial somewhere else. When do you think this will be resolved? Forgetting about any court time or anything.
I need to speak, the victim in the other case is his mother. And I have to have a conversation with her regarding the case and what she sees best.
And when did you say you're going to be tied up?
The 24th and the 30th. Those are the two cases that are set right now.
I mean, I've got a trial next week, but this is a plea, right?
Yes.
We could fit him in during the trial. Well, I was thinking about like even the 19th. Would that give you enough time?
As long as nothing well, no, I need to talk to the victim, and I've never spoken to her before. Can we do this off the record real quick?
Sure.
Yeah, I had to basically have a come to Jesus meeting with her and try to convince her to do something different than what she wants on that case.
All I can say is I've spoken with her, and I won't say, and it's Mr. Bridges' responsibility. I don't think it's going to be that difficult, in my opinion.
But the previous notes show that she's been consistent on what she's been asking for, and I'm going to have to convince her to do something different. And I'm hoping that the fact that we put mental health into this case, that she'll be more amenable to us doing something different and reducing the charges.
What day were you suggesting?
26th, I'll be in Judge Edwards. not Judge Edwards, Judge, Judge Barwick.
I mean, the 19th is a week. You don't think you can get a hold of them in a week?
I could try, Your Honor, but like I said, I'm preparing for 2 other cases, 2 other trials coming up.
I'll tell you what, let's tentatively put it down for 9 a.m. on Thursday. And if you don't get a hold of the victim, then we'll schedule it again,
What, I apologize, what date was that, Your Honor?
the 19th,
The
a week
19th.
from now.
'Cause I actually need to sit down and talk to her, see if we can get a convince her to do something different. Then I have to go to somebody else and say, hey, this is what we want to deviate from and do. And then I have to convey it to him. He's gonna have to convey it to him and see if he's gonna accept it. And then,
Well, I mean, we can schedule, I mean, my only thing is, so you're asking me to kind of hold on to this so he doesn't get,
Yeah, I think that would just throw a wrench into things if he gets taken to Jackson and he has to be brought back, and that inhibits my communication with him, obviously, too. So
it usually takes about 30 days to get him out of here, right?
I generally, but
this would be the one that,
don't wonder, that's not an ironclad rule.
I understand.
let's do 9 a.m. on the 19th and just let's stay in touch with Mr. Bridges. If he can't do it, then we'll schedule it at some other time that fits in his schedule, but
And normally, Your Honor, I say whatever the court says, but unfortunately I have those other 2 matters that have been specially set, so. Barwick might not go through though, so.
All right.
I think I'm number 6 on her calendar.
all right, well, let's do that and let's get on with this one. So, Mr. Smith, do you understand the nature of the charges against you?
Yes, sir.
You've just heard from ADA Bridges explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation or the plea agreement, and I could sentence you as I deem appropriate?
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Ms. Clark, you satisfied your client's competent sufficient factual basis for entering the plea?
I am.
Okay, I find there's sufficient factual basis for the charges. I also find your plea of guilty to be knowingly, voluntarily, and intelligently entered. I will accept your guilty plea and sentence you to the recommended sentence as follows, which is count 1, no prost. Count 2, 10 to serve 5. Count 3, 10 to serve 5, concurrent to 2. Count 4, 5 to serve consecutive suspended. That's the possession charge. Count 5 is 12 months probation, concurrent to 2. 6 is 12 months probation, concurrent to 2. And 7 is 12 months probation, concurrent to 2. The indictment skips 8. And so count 9 is a criminal trespass charge, which is 12 months probation, concurrent. Count 10, the other possession of a firearm charge, 5 years consecutive suspended, special conditions of a mental health evaluation and follow all recommendations, no violent contact with the victim or the son, and stay away from the incident location.
Yes, Your Honor.
Anything else?
Nothing
Okay,
further,
that's
Your
good.
Honor.
Okay. And stay in touch with Mr. Bridges on next week, and we'll see whether we can get it wrapped up next week.
Like I said, I'll come and see you before that. Or probably next Wednesday. So. I'll come and see you.
Yes, thank you.
You know what I'll do, when you print that up, I'll just sit that on my conference room table and we'll let it sit there. His disposition.
Oh, okay.
What is this?
That's for Lee.
Oh, what'd you say? On my conference table is the only safe spot in my office now.
Yes.
You want to do Michael's?
I need to go speak with him, but I shouldn't.
All right.
Okay.
Yeah.
Who's Michael Spence?
That is Shama's case, and she sent an email that Nalda, Miss Charles, would be.
Miss Charles.
And don't forget the other young lady.
This young, no, I'm gonna go.
She sat for one of my trials. She was not the lead on it. Yeah. Yep, Julio Cortez Navarez.
Why do I not see?
Yeah, was he at?
Oh, he's on the one.
Oh, so he's not up yet.
He's not here yet.
So it's not.
Oh.
So he needs to talk to a young lady back there too, so he can do that
Oh,
while he's back there.
I'll let him know. We didn't bring none of the 1 o'clock people up there.
Oh, okay.
Gotta get signed.
We'll bring them up once you take.
Oh.
Yeah, so. Yeah, so Carol, we'll bring them up after you take everybody over. Out there? No, we didn't bring anybody from 1 o'clock up yet.
So he's talking to who?
He's gonna talk to one of the females, there's 3 of them back there.
Let me come off and so y'all can switch out.
Yeah, you're fine, Your Honor. And Ms. Jones, you don't need to go back.
I have mine out of custody.
You've got one Satterfield.
I got Carrie Evans.
Everybody else is trying
That's
to.
it, we trial on Monday.
Apparently,
I believe it is,
It's
but I
funny.
think the conflict attorney has a conflict.
Yeah.
Yeah, I don't.
I was unreasonable.
Yeah, I don't know.
But we've got someone else.
And I just have the
I'll be
misdemeanor.
back there. Yeah.
Yeah, I know, my client's just a misdemeanor, so they need to cut this. It's literally a charge of police or man. We've got another case pending, CP, so.
I don't know where he. He didn't show up. I don't know what happened.
What's up with all these attorneys not showing up?
Well, we need to make note of that too. These attorneys are short positions.
17. Yeah. On the case.
Your Honor, I'm present on Zoom, Ms. Williams for Mr. Satterwhite.
That's what he's going to talk to right now.
All right, let me go back. You guys need to switch out, right?
Yeah,
All right.
Well, just come get
Just come get.
Yeah, he's good.
We're gonna have to reset it.
Last thing I got from
That's right.
Scott.
Yeah, he was.
So I thought he was gonna come in. and, You know, something. Yeah.
Yeah, because I didn't order on that motion.
Got one, Woods on the bottom.
Oh, you're okay. I don't need a moment.
Pretty good, how you doing?
Yeah. I'm just laughing.
He said if he said. What he think to do is to.
Bring him out.
So you're asking whether attorney your client.
Yeah. That's what I was. Yeah, I usually do a nice one in the theater. Sister Amy. I went to see one a week and a half ago, and they wouldn't let him out. I was like, what? I said, man, they're not letting you out because you're a mess.
Oh, you're talking about, you want probation?
Yeah, he was, I was.
So, that's what I'm trying to tell you like this.
I'm trying to think. Right,
Maybe not, if you come up at one, would. Yeah, I talk about this. No, you don't ask me, because I know my turn. Yeah. Is it? Yep. Okay. You don't even come back. So you said it goes- Oh, we gotta go down, we're gonna go down and we gotta. Yeah, tell her I will try to get to the academy. Oh, but we good. That's why we got 1 o'clock. 1 o'clock. Yeah, so we take the ones that already been saying. All right. So just stipulate. Leak good, right? Leak can go down, right? The leak got hung, right?
It's got a sign.
I was like,
Sign.
nah,
Good,
bro.
we'll get you out of here quick.
Uh-huh.
Except he's not even up yet.
Yeah.
All the best laid plans.
What about Bonner? Bonner, what's the name?
He's done. Connor.
So
Did you
roads,
already bought it?
roads and vines can go.
That's your first? Yeah, roads.
So reset. It's reset. Yeah, he knows it.
So roads, we got roads, Vines, we got Lee, we got Bonner. Smith Shaquan, right? He's already took.
Yeah. It's done.
And I think that's it. And everybody. Then we bring up all the 1 o'clock. What about cleanups?
Can I speak with Mrs. Hunter?
Because they, wait a minute, Bridges can go.
Reed said it too.
Young needs to stay.
Okay. What about Reed?
So, I mean, wait,
Hey,
you know
Wallace,
what,
just let me know
wait, leave Reed, so we can make it. Cause I don't want her to be here, but like, well, nobody said anything.
Wallace, don't take nobody down yet, bro. I said, just hold what you said, don't take nobody down yet. Not yet, wait till. No, go ahead, take it down. No, I know I'm supposed to take down, but I was letting him know, like, to let me know.
Oh, okay.
Yeah, cause, you can't transfer the money, so.
Okay. I'm gonna say, no.
I think we trying to move the inmate by themselves. Someone doing something happen, they coming straight. They had a. That's good. Who is that, man?
Oh.
I think it's still, excuse me, I think it's still the oldest case. Yeah. Or I think conversely, even if you have an older, but it's out of custody versus a newer. In custody. Yeah, that should. It would seem to me the one in custody should go. But sometimes it's just a matter of the judge who least hates their toe stepped on. Right?
Yeah.
Adams, yeah. I haven't had the pleasure to be in front of her. I don't know why I have that song in my head. It's so weird and random. So, Sally, are you gonna get that to?
I'll send it to him.
Okay, Ms. Roberts, because she was texting me this- or emailing me this morning.
Yeah, I'll send it.
Okay. I don't know why I'm always the contact person for Sally. That's like fine. And the only reason it is because he won't sign a release. Well, it makes me think of this moment.
If you try and fire her.
Yeah.
We don't have court tomorrow, do we?
I think we have tomorrow. I'm hoping he would say no, he would agree with me about. He wants to do a. Family conference call. So everybody who's. Now. Send y'all up, send
What are you doing, sir? Thank you, Sandy. Woodson, that's my colleague's part. Oh, okay. They already made an announcement. Already made an announcement. I think, sir. Didn't,
I don't know.
Christina send you something this, I have a brain for looking right at you. Miss
I
Kathy,
try to print them.
regarding, Woodson's cases.
I don't think she wouldn't be here today.
Yeah.
She wants to reset.
Stick to the call. They hear the information.
I appreciate it. Good to see you.
Mr. Bridges. Yes, Mr. Brown?
Yes.
Ms. Brown.
So it's, if you can to stay, so y'all can make an announcement and.
Okay. All right.
Okay.
You're ready to be done.
This is third
Bye.
case.
Me too.
I haven't had any.
I would think so.
And a bag of chips. See. You usually have a protein bar and I forgot it. Yeah, same thing. This part.
Little practice. Lucky though.
No, I'm good.
Okay.
I'm fine. Chips will pull me through. It was more organized, to bring like a little lunch, but.
Antoine Smith?
Yeah.
10 years. Probated?
Yeah.
Okay,
Yeah.
want to make sure.
You know, I have a funny story. When I moved from Georgia, South Carolina. There's still a shared an office next to me. It's like, why do you? I'm like, that's just something I've been taught. Probation. They always just say probation.
Yeah.
And then when I got back here and I learned spend because of our code. Kelly was on fees, right? And then I was just like, you know, I should email Mr. Shealy now and say, I finally figured out why I say probation.
Exactly.
Yep, me too. That's what I was used to.
Yeah.
I always think of that. Then he'd probably be like, well, I don't know what this is in reference to. Because he still practices and stuff. I like the whole South Carolina did it because you could only be on probation for 5 years. That was just the sentence. So if you got like a 15, say 3, it wouldn't be balanced probated. It would be, yeah, it'd be 5 serve 3. With like 3 years of probation, whatever.
What would happen?
It would just go away after the probated portion. It could be, no, so yeah, after 7 years. You could not be on it. Yeah. Usually it was just 2 years probation. And then you'd have all others that if it was restitution. Probation terminates. And it's funny because I had a client who had probation up. He's like, I think it's over because it was a PTUP. And I was like, you know, I actually know what you're talking about. I think that's probably pretty reliable, yeah. Yeah, I was surprised he even knew the acronym. PTUP. I guarantee you he was. It's probably a serial shoplifter. Every once in a while, we get those shoplifters who are professional. And they're just hitting the coast or whatever they're doing. And they've got the keys. No, Spartanburg. But that's just it's a major road. I think if you understand, I've heard of it. It's near Greenville. It's like 20 miles. Yeah, they always call it the blue collar. Yeah, it's the blue collar cousin of Greenville. We had a jailhouse attorney, literally. So he would just go through the jail and see who wanted to plead in and out. And so whenever he yeah, just they would figure it out.
Yep.
When I said I wanted to plea, I didn't mean that. Yep. Yeah. Well, and I think they could waive, I just don't really remember how that worked anyways. That was James. But we would do that too, because we had judges riding the circuit. And so we get favorable judges that would come in. And that was like a get out of jail card essentially. And we would just line people up in the well of the court. And it'd be like, how do you plead? How do you plead? How do you plead? Yeah, it was crazy. A lot different than it is. And then you had your domestics. After your third or subsequent, it was a mandatory year. There couldn't be probated or suspended. So they didn't ever want to go to prison, so we just, and then it's mystery. You gotta love those small counties in a way. Here. Well, in Oklahoma, they used to do orders, right? Order of release and order of commitment.
Yeah.
And so that's all the documentation.
Yeah.
Yeah, I've never seen. I hate to use the word proactive. That's what we can- Yes, it's almost like show me how to, prove to me actually. Or challenging others. This is what it's. It's at 8:20 or 8. I know I left work a little early. Barbados. I'm guessing because the Dodgers. So. Want any extra? Because I essentially. Well, that's how your murder.
They send they.
Well, I used to just have a link, but now when I go to my Dropbox, it says you're out of storage and I can't access anything, and then it gives me a link that I can pay for it. Yeah. Well, and they also, there's supposed to be this one, but I can't. This Clinton County Department. You're supposed to be able to save that. But every time I try to save something to it, it's too much. it tells me it's full. So just like now, I'm rocking her place now. I was trying to look up something on the Crazy Little, and I can't. So now I might have to just fight with that. So, and why can't it just be? And I took it to the file. I'm sure it was one of those, I was cleaning and I put it somewhere. Now I don't. I heard that. I guess that's Fulton County. Or Clayton. Oh, good. I wonder if she was on the phone. Mhm. You don't get that full news. Don't notice. The exception. It's bad when you hear something like, oh, well, don't bring them in, you don't want to get back. But I don't know that I need to. It's just one. Well, I'm guessing. I don't- Oh. That's the language. Oh, the other. Supervision. Oh. Conversation. I'm like, well, we go Germany. You talk for everybody. And don't say nothing stupid either. Because we don't know what you're saying.
this with you, Sean.
Oh, yeah?
A little bit. My mom is German.
Oh,
so,
nice.
yeah.
That'll be cool.
Yeah.
I
Sharpen my skills.
I thought you were just having.
Yeah, well, I'd be more than happy. Maybe she speaks it better than
Very
me.
excited.
Good old Ronald.
I mean, like,
Ish Libidish.
that's,
I can remember the I just need to
That's a
learn all
sweet
well, I just saw that when
one.
she,
That's a sweet one to teach
Yeah.
you.
I'll make you remember this. When I did that, I love you.
Yeah.
I was like, you're not pronouncing it right. I'm like, girl, I'd be happy I can remember.
well,
that.
and so many of them now are being indicted as egg assaults when they started out as battery.
Right?
Would you say? Ich bin, yeah.
My name is Sean. Is that right?
I know.
You say, or you say Scheiße.
Oh, I haven't gotten
But I guess-
It's advanced, but like female, male. Takes me like, you know, how Spanish is,
Yeah, they have some of that in German. Yeah. Sister?
Yeah.
Yeah.
Get off. I'm just going to.
Yes, and Mallory's a really.
They
good
kind of
one.
sound, to me, they kind of sound like English words. Yeah. Yeah. Yeah.
Well, I just have
Sound like what I-
child molestation coming up. And I saw you and for those things. Why is he here?
Yeah.
Oh, where'd he come from?
Charlotte.
Oh, so you just got
The
a,
rotation.
which it seems to be no rhyme or reason.
You have the paperwork?
Crazy.
On Smith, I just need to speak with him for a
Okay,
minute,
okay,
but
okay,
we'll be
okay,
ready
I
to go
forgot.
after that. Yeah.
And Miss Charles, you're taking the Smith, please?
Yes.
How you doing, Miss Charles?
Can I get your signature?
Do you like karaoke?
Only if I'm sure.
I like karaoke.
So we still so we still got, we brought everybody up for 1 o'clock and we still got some people up. from, 9:30.
Dating.
So that's still not for here. You need to go back.
Yeah, just.
Oh, wait, well, no, let.
Yeah,
oh,
no,
let
gotta
them
go
do
back.
that.
Wanna go home or something? All the rest we still got, I see too many bodies back there.
Come on now.
And then you went, where did the other attorney go? Cause he wanted to go back too. For Woods?
Yeah, I don't know.
Well, if we got two, we have two for wood. That's the
Oh,
Brown.
did you wanna go back?
Oh, yeah.
Okay, come on.
Let me go to the other one. He's the one with the weak.
Yeah, I'm talking about the other one though.
Yeah, I know. There's one place that's driving it. Oh, Mr. Bridget, you gonna go look for him?
Yeah.
Oh, okay, I was going to.
Is that Mr. Woods?
Yeah, Mr.
Oh, thank you. Hey,
I had to print that doc.
I just have too much caffeine is from, so I don't have energy to burn.
It's a lot of energy to burn. You wanna go back there?
I was about to-
Well, exactly.
That's a little too much energy. Hey, quit.
Y'all doing all right? No.
Oh, Lord,
You're not open.
huh?
You're not open. Other than that, what are his attorneys back there?
I think Mr.
I
Clark.
don't know why they don't put them all with the same attorney.
Well, he got 2 different cases.
You got 3 different cases.
You're right. Well, I think Mr. Brown was on 2 of them and the other
Sure.
one's on 1.
That's what I understand why you just put them all on the same place.
That's what I hate rape and I'm afforded. So.
We haven't really done much. Court takes it out of you.
That's because y'all ain't in YSL.
Y'all really be crying, man.
I wouldn't cry. I couldn't do it.
Y'all would be crying. If y'all think this is bad, go in there.
Yeah, it would be hard to be on all the time.
I don't even like.
Yeah, because how many defense attorneys are there?
I want to say like 7,
Oh,
6.
seven.
But good thing is, some of them have already been sent. to court. Like the one says like only 6 of them left.
Still. I think our office somehow escaped.
I wonder if they gonna do the wife and you know, that's the rival game of YSL. YFN is.
Let somebody else have that.
Are they getting indicted too?
No, I was just asking, that's what I'm saying. I haven't heard anybody mention it, but those two are like, they got a lot of history. Those are 2 different games.
I didn't know.
Stop trying to come.
I
I
don't.
don't think it's not what happened on this thing.
Yeah, no, I guess you never know. We could wake up tomorrow. and- We
I
got
don't even think
we got enough going on though.
they started the Trump trial already. Right?
Who?
The Trump thing.
Have they though?
I don't know if they
This
started.
is not trial, but they're selecting. Yeah. they
Well, I
started
know,
that.
didn't 2 people file statutory speedies, I think?
I'm not sure. I just know.
I think
one
Sidney
of the
Powell.
deputies Was telling me that they started yesterday.
What a crazy.
That's a lot of defendants though in that, right? Like
Yeah,
60-something?
isn't that McAfee though?
Yeah,
Well, which one then did?
McAfee has that one, and then, that has the city.
Oh, okay. I knew there was another one.
Yeah.
Co-defendant, right?
Hey, Wallace. Is Corey, did we take Corey Rose down?
Yeah, but that's all.
Corey Rose.
Yeah, well, he's.
Rose, R-H-O-D, yes.
Okay. Got it. I'll be right back.
I'll get lost.
Okay.
I mean, Miss Cathy, if we took him down, y'all really need him.
Oh, no, he's still
up,
here.
yes.
No, keep him here.
All right, keep him up here.
Yeah.
All right, good.
You ready to go, sir? Got another plea.
On Smith, yes.
Don't be telling everybody.
Oh,
she said Shalaka. Oh.
See?
Hey, man, her name is Shalaka now.
Oh, the series, that one.
That's not even the best one though.
It's not.
All of them, all of them.
I miss Paul.
Wait a minute, is that the last one?
Yeah.
Was it him? Oh, okay.
I miss Paul, I'm not gonna lie, that's my boy.
I'm so sad. I just. Yeah, he just died.
Yeah. And I'm not gonna lie, I just like that. I just sit there with that long hair. What's his name? I don't know. I don't. Sure, I saw.
Oh, you're talking about, someone's. Hold on. Give me a clue. Is that my or Jason Lamar?
Oh. Yes.
Court come to order, remain seated.
Yes.
Yeah.
Hey, how are you?
Michael Smith.
Your signature, realized it didn't get it, and we went over last week, the plea paperwork.
Before we
So
do
this
this, please.
signature right there is on the question. with rights.
Charles.
Yes, Your Honor.
Let's take a second.
Oh, sure, no problem. No problem.
I'm sorry. Yeah, we got some other folks I think we can take care of here.
Okay. I'll wait.
Let's go,
Let's go ahead and work, take some announcements real quickly. So position 1, 2, and 3 and 4, Satterwhite's and Evans. What's going on with Satterwhite?
I guess there's a lot of layers to that question, Judge. So you may recall, Judge, that you had asked me to represent Ms. Satterwhite. There wasn't anybody to represent her in the hopes that we could expedite resolution in this case, and I realized that has not happened. I know it's on your trial calendar for next week, but it's my understanding that Ms. Williams is set to start a 3-defendant murder trial in front of Judge Whitaker on Monday, and I don't want to speak for her necessarily. Judge, my client.
That's correct, Mr. Melnick. I'm here.
Yeah, thank you.
Well, and we'll get to that. She's set for trial in my courtroom on Monday as well. So we'll have to discuss all that.
Okay.
We'll get a little presumptuous right now.
I understand.
All right.
Judge, when I'd taken this case, it wasn't really with the understanding of me trying the case.
Yes, I know that.
So, and the state has made a probation offer on Ms. Satterwhite to hindering the apprehension. Honestly, I think that overstates her actions in this case. I think that what she did in this case constitutes nothing more than perhaps misdemeanor obstruction. And so, despite the parameters that we had talked about when I took the case, I'm not going to plea her to a felony just to get rid of it or anything like that. So what I would actually ask you to do is sever Ms. Satterwhite from Jimmy Satterwhite's case and let the state proceed with Jimmy Satterwhite in whatever manner would be appropriate. I will also say I think that Ms. Satterwhite is an essential witness in Mr. Satterwhite's case. And for that reason, I also think that severance would be appropriate.
Okay, and first, I appreciate you taking this case on, and yes, there was, and you know, I wanted you to work on it and asked you if you could see if it would go to resolution, but it certainly was not intended, and I know you didn't understand it that way, to pressure anybody to take a resolution as well. So I've got you. I know you've got your motion to sever. How about Mr. Let's go ahead and talk about Evans next.
I am present on that, Your Honor. I think that Mr. Evans is probably in the same seat as Mr. Melnick's client. He's just been charged with 1 count false statement and obstruction. I know that Mr. Whitenhour and I've talked potentially about resolving this, but I don't know if we've ever gotten a firm offer in regard to this case, but I can certainly get with Mr. Whitenhour, but we would just join in on a severance motion.
All right, Mr. Whitenhour, has there been an offer made for Evans?
Yes, Judge. I believe, communicate an offer on Mr. Evans. I'm trying to look back for that now, but it was also a probated offer. I don't have it here before me. Yes, that's my recollection.
All right.
And Mr. Whitenhour, you can just email that to me again, and I'll be sure to discuss it with Mr. Evans.
Okay. Again, it's my recollection I did. If I did not, I apologize. I will send you either a forwarded email or an email.
Yeah, I was just looking for it. Have emails that disappear for some reason. It's kind of weird.
Sure.
Okay, and Miss Williams, let's get to your client now, who's been in jail for almost 4 years. So what's your announcement?
Your Honor, I would be ready to go to trial, but for there being a specially set, I know that I am, on the trial calendar for you as well, but Judge Whitaker specially set this trial back in June when I first got on board. It is going to be a 2-week, 3-defendant murder trial. We had pretrial conference on yesterday, so we are set to go. And that client has been in jail the same amount of time. I mean, I don't know what to say other than I can't be 2 places at one time. But that is specially set. We're first up and ready to go. And we had pretrial conference on yesterday. So I'm asking for a continuance. I told my client that, I'd be asking for a continuance and he's okay with that. And in light of there being the severance motion, we'd ask for a continuance.
Well, the severance motion and what holding that up, I can do that very quickly. And what's the age of the Whitaker? What's the case number on the Whitaker case?
If you'll give me 1 second, Your Honor, I'll look it up.
I mean, this was a date that y'all asked for, right?
We'd asked for this as a final plea date, Your Honor. I thought that we were going to be able to come to a resolution. And then after speaking with my client, he ultimately rejected the offer. The case number on Whitaker is 19 SC 172396.
Yeah. All right, we'll continue it.
Thank you, Your Honor.
Mr. Whitenhour, you'll get an offer for Evans if it hasn't been out there.
Yes, Judge. Understood.
And you're still in talks with Mr. Melnick?
I have emailed Mr. Melnick that offer. It's my understanding, based on previous conversations I have with him and based on his announcement just now, that he's not inclined to recommend to his client to accept a plea to a felony probated.
Well, I
sentence.
mean, I don't know what he's discussed with his client, but it the client's decision, but.
Sure, of course.
Yeah.
I'm happy to continue speaking with Mr. Melnick about a way to resolve this case.
Okay, we'll continue it and we'll try to, get this scheduled as quickly as possible, given how long Mr. Satterwhite has been in jail for.
Understood,
But
Judge.
as of right now, there's no reason to have y'all hanging out there, so I'll pull you off the trial calendar for next week.
Thank you, Judge.
Anything else?
Nothing from the state.
Okay.
Not, Judge.
Thank
All
you.
right.
May we be excused?
Yes, you're excused. All right.
Thank you.
Okay.
All right. All right. And so Garrett Smith is going to do a plea?
Michael Smith, yes, Your Honor.
Michael, and you're Michael Smith? All right. And then what's the announcement on Corey Rhodes, position 6? I guess she didn't show, we already had that this morning, didn't we? She didn't show up.
Your Honor, I got a notice that this was for the 1 p.m. calendar today.
And people specifically asked us for these.
It wasn't just about nicotine.
Okay.
He has a case that I'm not appointed to, and that might be it. And I have reached out to the conflict defender's office to ask them to appoint me.
But people who were smokers who.
All right, what's going on with this case? So this is a final plea add-on?
Yes, Your Honor, I think that we were doing a motion, a 418 motion. I'm not sure if that's going forward.
No, the 418 motion was that was this morning.
Oh, okay, so that's on, okay. Well,
That was the other case for Corey Rhodes.
I'm trying to get appointed to all of his cases, Your Honor, because it's a little bit confusing. I've asked the conflict defender to appoint me to all of them so that I can get on track.
A lot of times engineers, they know so much about the product that they don't really understand a lot of the pain points. There's a lot of pain points with their early plume device.
The number one thing was it's power.
Well, why were we scheduled on the final plea for this case? Because it's a special add-on.
Actual heating element, there was a danger of singeing.
You know why?
Your mouth.
All right, I think, I realize there may be some confusion here, but I think you all asked to be put on this final plea calendar for this 23 SC 185699 case.
I didn't, Judge. I was confused as to why I was put on because we were just in court the week before last. So I had no idea. I just received the notice.
He's falling Woods.
Woods.
Woods, yes, he's falling Woods. That's what it is. He's for defending Woods. That's probably why he's put on.
That's right. I'm trying to figure out.
All right.
I just put it on the table.
All right, so the issue is Woods.
Yes, Judge.
Where's Mr. Woods' attorney?
You got two.
One here, the other one is outside.
He went back outside.
Where's Mr. Woods? He's back there. All right, we'll get to y'all then after we take this plea. You ready, Miss Charles? You done?
May be excused, Your Honor, yes.
You're excused.
Your Honor, do you want me just to stand by? But I don't have any business with Mr. Rhodes that's gonna happen today.
Except for that 418 that we were gonna do.
Okay, are we doing that? Okay.
No, that got reset. You and Wilson were gonna, for some reason, you both weren't there.
I didn't get notice of that. I had no idea. I thought that I got notice for 1 p.m. So I wouldn't understand why we would have been on a 9 and a 1.
I mean, I'll look it up if you want to get into this notice argument here. Let's see.
For any investor who could help please succeed.
Japan Tobacco International approached us to invest in Flow, $10 million.
But either way, I wouldn't have been prepared to move forward because of the new charge, and I'm not appointed to that, so I didn't know what was gonna happen with that.
Well, I mean, it was a 418 motion. I would have expected to be prepared on that.
And well, I got an email yesterday from the state about a new case that I'm not representing him on.
We can't just scrap it and go.
Here, let's see motions here. Miss Oakham was on, ready to do it. I'm looking. I'm looking 9:30. Kyla Bumpus.
So it helps achieve your permission. Maybe it's not.
When did it go out?
But that's not going to enable them to expand.
Went out in September. September 28th.
To what address?
Really?
I'm saying
All
because
right.
I received a notice for today in the mail yesterday, last night when I went to check my mailbox. I mean, my office mail.
So with that money, they pivoted. They didn't come out with, a new.
Don't y'all get emails and stuff? 3350 Riverwood Parkway,
That's my
Suite
address.
1906.
That's my address.
Yeah.
Paper on it, or loosely tobacco.
What? You still got something to discuss on it? Was it in the email too? Well, anyway, you got emailed and noticed on it. What's done is done. But yeah, the 418 motion, I don't think would have had anything to do with this new one. So anyway, I guess just pay attention, and we've moved on from that.
Okay, Judge, my apologies.
All right. All right. Well, you're excused.
Thank you.
All right. All right. Now, what position is Smith? Okay, I got it right here. All right.
Yes, sir. You may spell your first and last name for the court.
MICHAELSMITH. Michael Smith.
Okay, so this is 22 SC 1855556, Michael Garrett Smith, who's present in the courtroom with his attorney, Mr. Philip Clark, and we have Ms. Charles with the district attorney's office, and you have a negotiated plea to present?
That is correct. Your
Go
Honor.
ahead, Ms. Charles.
Your Honor, the defendant has no prior criminal history, felony convictions. Had this case proceeded to trial, the state would have expected to show that on February 8th of 2022, officers responded to 305 Birch Real Drive, BIRCHRILL Drive, in response to a call about a domestic altercation that was occurring between the victim in this case, his then girlfriend, Samantha Hughes, HUGES. Officers were able to put the parties apart and separate them. And at this point, Ms. Hughes explained that she had just come back from work and believed that the defendant had been drinking, and they began to argue about him being drunk. During the course of that verbal discussion, it escalated to the defendant punching holes in the walls and then breaking several items of furniture, including the glass tabletop, which he broke against the wall. At this Hughes asked Mr. Smith to leave the residence. He refused to leave. He then approached her, shoved her against the wall, placed both hands around her neck, and began to choke her. Ms. Hughes did not lose consciousness. She was able to punch him in the face, causing him to release her. Officers observed redness and marks around the neck of Ms. Hughes and took photographs on their body-worn cameras to confirm the same. However, she did refuse medical attention at the scene. Officer Foster confirmed that Mr. Smith made a consistent statement to that of Ms. Hughes, saying that What caused the altercation was in fact the argument about him drinking. He admitted to punching the holes in the walls. He admitted to breaking the tabletop. He stated he may have put his hands on her, but it was during the heat of the moment. So he doesn't remember exactly how that came to be, but he may have done it. And he admitted to shoving Miss Hughes. Officers did notice dried blood on both of the knuckles of the defendant. And he also refused medical treatment at the scene. Lastly, Your Honor, there was a roommate who was in the house, a Mr. Avery Waterman, and he said he was there. He heard the altercation, but he had his headphones in, but he felt the house shake. He couldn't state exactly what had happened, but he did see the altercation, especially towards the end when he had attempted to break them up. Your Honor, the state's recommendation is as follows. As to count 1, aggravated assault, strangulation, the recommendation is 7 years to serve 2 years with the credit for time served. And as to count 2, battery, family violence, the recommendation is 12 months to serve in confinement concurrent with count 1 with the special conditions as follows. He will have no contact with the victim, in this case, Samantha Hughes, that he will complete a mental health evaluation and follow all recommended treatment, that he will complete a family violence intervention program, that he will also complete a program with the Salvation Army. I believe that was a substitution agreed upon by Mr. Clark and Ms. Iqbal.
What was the Salvation Army one again?
That he will enter into the Salvation Army's inpatient program for treatment for any drug and alcohol issues that he may be suffering with, and that he will pay $1,000 in restitution to the victim.
And the only correction is commuted to time served was our understanding rather than the credit for time served.
Okay. I mean, I believe he served, what is it?
He's been in 602
600.
days. at this
Okay.
point, Yeah.
And 12 days.
602 or 600?
I thought I had
612.
12. I have 612 days
yes,
to date,
yes.
yes. And he's also be requesting to be treated as a first offender.
So commuted versus credit is significant.
It is, Your Honor, yes.
I can't, I'm going to defer to Mr. Clark. I have abbreviation CTTS, so it could go either way.
And then first offender?
Yes, Judge.
When is the restitution due by?
Would have to be paid within a year of sentencing, Your Honor.
Okay. All right, Ms. Charles, I guess his criminal history must not be very significant.
No,
if
Your
he-
Honor, this is to be first.
First offender.
Yes.
Can't, that's right. You already gave facts, right?
Yes, Judge.
Okay, go ahead, Mr. Clark.
Okay, no, Judge, I'm going to read the plea soliloquy now for the guilty.
Oh, shoot. Okay. I felt like there was something missing there and
In other courtrooms, they did the reverse. I thought I'll try it.
you
The new one.
reversed it. That's what you
Yes.
did to me. All right.
Mr. Smith, are you under currently the influence of any alcohol, drugs, or taking any medicine that affects your ability to understand these proceedings?
No, ma'am.
Is there a medication that you normally take that you have not been given today?
No, ma'am.
How old are you?
38,
How far did you get in school?
10th grade.
10th grade. Did you ever get your GED?
Yes, ma'am.
Okay. Are you able now to understand, to read, write, and understand the English language?
Yes, ma'am.
Did you go over the indictment with your attorney?
Yes, ma'am.
And do you understand what you're being charged today?
Yes, ma'am.
Speak up.
Did counsel go over the minimum and maximum penalties for each charge that you're pleading guilty to today?
Yes, ma'am.
As to count 1, for the record, aggravated assault, strangulation, the minimum would be 1 year, maximum would be 20 years. And as to count 2, battery, family violence, minimum would be 1 day, maximum would be 12 months. Do you understand that you have the right to plead either guilty or not guilty to these charges?
Yes, ma'am.
Do you understand that if you plead not guilty or remain silent, you may receive a jury trial?
Yes, ma'am.
Do you understand that the state and the defense will make a joint recommendation to the court because this is a negotiated plea of guilty?
Yes, ma'am.
But the court does not have to accept the recommendation. The court can sentence you to the maximum on each charge and run those sentences consecutively, which means one after the other.
Yes, ma'am.
Do you understand that if the court decides to order a sentence that is different from that which you negotiated, you may have the right to withdraw your guilty plea?
Yes, ma'am.
Do you understand this plea may be used to enhance sentencing on other convictions in this jurisdiction as well as in other jurisdictions, including the federal courts?
Yes, ma'am.
Do you understand that if you're placed on probation of any kind, criminal laws of any governmental unit, or any special conditions of probation without being subject to revocation for the balance of your sentence?
Yes, ma'am.
Do you understand that you are not allowed to possess nor use a firearm while on probation?
Yes, ma'am.
Are you a United States citizen?
Yes.
Do you understand that there may be other adverse or unfavorable consequences as a result of your guilty plea conviction, just as there would be from a conviction after a trial?
Yes, ma'am.
For example, your plea today may affect the right to vote, the right to hold public office, the right to serve on a jury, the right to obtain a passport, the right to receive, possess, or transport a firearm, or the ability to obtain employment.
Yes, ma'am.
Do you understand that by pleading guilty to a felony, if you use, receive, possess, or transport a firearm, or use a firearm in a crime, you will be guilty of a felony which may carry a sentence of 1 to 15 years in prison?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defenses, by entering a plea of guilty today?
Yes, ma'am.
Do you understand that you also waive additional rights by pleading guilty, the first of which is the right to a trial by jury?
Yes, ma'am.
That you waive the right to remain silent and not incriminate yourself?
Yes, ma'am.
That you waive the right to confront witnesses against you?
Yes, ma'am.
That you waive the right to the assistance of you or to court-appointed counsel at a trial of your case?
Yes, ma'am.
That you waive the right to the presumption of innocence?
Yes, ma'am.
The right to testify on your own behalf and to present other evidence?
Yes, ma'am.
The right to subpoena witnesses and compel the production of evidence?
Yes, ma'am.
The right to have the charges against you proved beyond a reasonable doubt?
Yes, ma'am.
And the right to appeal if convicted of these charges after a trial?
Yes, ma'am.
Mr. Smith, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea today?
No, ma'am.
Is it your decision to waive these rights and enter a guilty plea because you are in fact guilty?
Yes, ma'am.
How then do you plead to the count 1 of aggravated assault in indictment 22 SC 185556?
Guilty.
And how do you plead to the count of battery family violence in the same indictment?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of all of the charges against you?
Yes, ma'am.
Do you understand you may only have a limited right to appeal this guilty plea conviction?
Yes, ma'am.
Do you understand that unless counsel is substituted or permitted to withdraw, your attorney will continue to represent you until either the end of the current term of court or 30 days from today's date, whichever is later?
Yes, ma'am.
Do you understand that you have 30 days from today to file a direct appeal?
Yes, ma'am.
Do you understand that you only have 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of your guilty plea?
Yes, ma'am.
Do you understand you have at least until the last day of the current term of court to file a motion to withdraw your guilty plea?
Yes, ma'am.
And do you understand that any of these filings we have just discussed must be filed by your attorney unless you're representing yourself?
Yes, ma'am.
Mr. Smith, are you being asked to be treated as a first offender under the provisions of the First Offender Act?
Yes, ma'am.
Have you ever entered a guilty plea or pled no contest or ever been convicted of a felony in the state of Georgia or any other jurisdiction?
No, ma'am.
Have you ever been sentenced for any crime, felony, or misdemeanor under the First Offender Act?
No, ma'am.
Has your lawyer explained the First Offender Act to you?
Yes, ma'am.
Do you understand that if you violate the terms of your first offender sentence or commit a new offense while on probation, your first offender status could be revoked. You could be adjudicated guilty and be resentenced up to the maximum sentence for each charge in this indictment?
Yes, ma'am.
And do you understand lastly that if you successfully complete your first offender probation and are discharged, you can honestly say you have never been convicted of a felony?
Yes, ma'am.
Your Honor, we ask that you accept the recommendation as presented. This concludes the state's presentation.
Mr. Clark?
Yes, Your Honor, we're asking the court to accept this plea as well. As Your Honor had heard during the recitation of the facts, alcohol was really the driving force behind this incident. Mr. Smith doesn't have any real significant history whatsoever, although he has struggled with alcohol use in the past. He's now been in jail for this offense, as you've heard, for 612 days. He has expressed to me during the course of my representation that he wants to get help to make sure that he's never in this position again. To that end, social workers with our office got him acceptance into the 6 months to 1 year program at the Salvation Army. The first 6 months of those are essentially strictly inpatient, where he's going to have limited freedom to go work or do things that he needs to do before earning those privileges. I'd tell the court candidly, I know Mr. Smith is taking this seriously. What he informed me was that essentially he's willing to wait as long as it possibly takes in jail so he can make a smooth transition from jail to the program without any gaps in time where he could potentially slip up. He does have an intake date available on Monday at 8 a.m. So I would ask if the court would be willing to potentially sign a transport order that he could be taken directly from the jail to the Salvation Army on Marietta Street. I'm not sure what the sheriff's office is with that right now with staffing, but I think that would set him up for the best chance of success. Other than that, Your Honor, he does qualify for first offender. We would ask the court treat him as a first offender, and I've explained the benefits and drawbacks of that to him.
Do we have you done transport orders before? We've done them, right? All right, well, that was gonna be my next. So you'll prepare the transport
Yes.
order, okay. I know, what's the maximum sentence for aggravated assault?
It's
20
20
years?
20 years, Judge.
And what about the battery family?
12
violence?
months with a misdemeanor.
Okay, so I just want to go over this a little bit since he's going to have some probation time. I know you've gone over the pros and cons, but I just want to make sure, Mr. Smith, you realize what you're getting into here with the first offender sentence. So if you violate the terms of your probation, court may enter an adjudication of guilt and proceed to sentence you to the maximum sentence provided by law, which you just heard is 20 years on the aggravated assault. You understand that?
Yes, sir.
Additionally, I want you to understand that if an adjudication of guilt is entered, you may be sentenced to a sentence greater or more restrictive than what I'm imposing today, which could be the 20 years. However, if you are so sentenced, you will receive credit for time served on probation against any new sentence. And on a positive note, if you successfully complete this sentence, you will not been convicted of a crime in this case, and your record when applying for jobs and whatnot will be clean. So have you ever been convicted of a felony?
No, sir.
You understand the conditions of the first offender sentence?
Yes, sir.
And you understand this is a once in a lifetime opportunity?
Yes, sir.
And do you still want first offender?
Yes, sir.
Okay, so Mr. Smith, do you understand the nature of the charges against you?
Yes, Your Honor.
You've just heard from District Attorney Charles explain all the rights you give up by entering this guilty plea. Is it your wish to give up these rights and have this court accept your plea of guilty?
Yes, sir.
Do you understand the court is not bound by the recommendation or the plea agreement? I can sentence you as I deem appropriate.
Yes, sir.
Are you pleading guilty because you are in fact guilty?
Yes, sir.
Mr. Clark, you satisfied that your client is competent in understanding that the plea is voluntary and there's sufficient factual basis for entering the plea?
I am.
Okay, the court finds that you, Michael Smith, understand the nature of the crimes and the consequences of this plea. There is a factual basis for the plea, and the defendant has knowingly, intelligently, and voluntarily entered the plea. The defendant has requested a sentence under the First Offender Act. The court will approve that request, withhold adjudication, and does hereby notify the defendant that this plea may not be withdrawn in the event the defendant fails to fully comply with the terms of the sentence I'm about to impose, which is the recommended sentence. On count one, it'll be 7 years to serve 2, commuted to time served. Count 2 will be 12 months to serve concurrent with count 1. You are to have no contact with the victim, complete a mental health evaluation, and follow any recommendations. Violence, family violence intervention program. And you apparently this has been already prearranged. You were to enter this Salvation Army program for drug and alcohol. And Mr. Clark, you send over that transport order. I'll sign that transport order, and you are to pay $1,000 in restitution within 1 year of. I'll make it within 1 year because the program is pretty intensive, right? With the Salvation.
The first 6 months, they're not allowed to have a job, the residents.
All right,
there,
so I'll make it 1 year. So it's a 6 month. I'll make it I'll make it 18 months to be, so you can focus on what you need to focus on those first 6 months.
Thank you, Your Honor.
Okay.
Thank you, Your Honor.
All right. Anything else?
See you.
No, Your Honor, that's all for the
All right,
state.
you're excused.
Appreciate it. Thank you. Yes. The back channel, sure. Yes, I will.
Thank you.
We have what? Do we have another plea?
Ms. Young, who was on the case management calendar this morning.
Okay. Let's see who this is. Yeah. This is a criminal calendar. So,
Yeah, I don't mind waiting out there because that's been subpoenaed since last week.
no, we're not addressing your issue today.
The subpoena was accepted and,
I'm not even arguing it with you.
okay, so what are you recommending tomorrow? Because I definitely come tomorrow. We cannot continue to hold on to this.
I'm not recommending anything. It's not a valid subpoena.
What makes it invalid? What makes it invalid? I had a new one issued with the correct. Okay, it has the correct, I guess, the new Shay Alexander assigned there. Your previous response was it had.
I don't even know what your subpoena is about, Miss LaRose. It doesn't make any sense. It makes no sense. It's not a valid subpoena.
It has it where it says.
I'm not here to argue with you. We're done.
I'm not. It says
All right.
ruling of all plaintiffs' motions.
All right.
He doesn't want to attend to the case, so you need to transfer it. Quit holding it.
Come on, man.
All right. All right, I'm gonna step out and then let me know when Mr. Clark comes back out. What why are you here, sir?
Woods, I'm trying to.
That's
Look
the
back
other
to
attorney,
it.
these are the two attorneys.
But Woods is back there, so we're gonna, Mr. Clark's talking to his client and we'll try to address you when we can. But
And mine though, can I look with that, because I have the Lester case. Wherever you guys do, I'll just ride along, because Gwinnett, Judge Dixon is waiting for me, Gwinnett, Mason.
And Your Honor, from what I understand, state has made an announcement, request reset, so.
Yeah, I think Ms. Clark emailed the court regarding her position, because I can't handle the case, but I used to represent Mr. Woods.
Oh, you remember I told you that yesterday.
And she sent an email regarding her.
Her daughter has.
oh, that's right. That's right. That's right.
Just told them to make it their announcement.
All right, so Brown has two of them,
I do. Yes, Your Honor.
and then, and so you can't have the case because you used to represent him, which makes sense.
Yes, you're making jokes about the last time.
Yeah. I remember, you know. I mean, you ought to be able to work out a plea, right? I mean. Depends on how much he likes himself. But, all right. Well, we're gonna have to reset this and have Miss Clark involved then. All right, you gentlemen can leave.
Thank
All right,
you.
all right, all right, bye-bye.
Have they talked to Mr. Woods?
Yeah, I've talked to Mr. Woods.
Because
Oh, he did ask if he can come
He
out
wanted to come out,
and
Your Honor.
actually, he was going out from you.
Yeah, the problem is that I've got another attorney back there and y'all, I can bring him out and I will tell him. I will tell him what's going on. All right. We'll keep it very high level and we won't allow your client to say anything incriminating. So,
Thank you.
okay. All right. Let me step out.
Okay.
When I saw that you were the previous. I just know my name, I saw an order with, so, you know, that was probably around the time.
I didn't know. I didn't know what she was.
I thought y'all were saying.
They got holding cells for that.
Okay, cool. If she comes back, she's a little. No, did you know or you didn't know?
My name is Richard Hurd. However, I sent an email to both.
So her paperwork might be legit, according to the judge.
So if she returns, tell her that she can go to Richmond Burton.
You trying to say outside. You can't use her when you say.
To go to see him at AD.
Look, you trying to.
If she returns, I doubt it.
I don't think she gonna come back.
I doubt it.
Nah. Cause she asked me, she said who she presided there.
Oh,
That's
so
what I
that's
said.
the way.
I told her, don't worry about it. I said, just know that you're not in this part. Bro. So, maybe she went to somebody else for it.
She's going to wait now. Well, we'll see.
I said, no, though, she came in with, when they usually come with all those bags, that means
Order.
they homeless too, right? She could have fooled me, though, she looked like she had legit, she looked like she had legit paperwork. Nice, not an attorney. Huh? She wasn't in.
Not an attorney.
No, she's not an attorney, but she told me she wasn't, she said that she's here for a hearing. Oh, but, yeah.
There's no hearing scheduled for her and her civil case. And the subpoena that she did.
So she got a legit case though?
She has a civil case.
Oh.
I'm not gonna say legit. She has a civil case. Subpoena she did is a subpoena she did on her own.
Oh.
It's not a subpoena that came from Fulton County. She made that up on her own. She's apparently suing somebody that she doesn't even know because of some name of some group that she's talking about trade rights. And I'm like, what's the trade right? Somebody use the name?
Oh, Lord, Jesus.
She need to be in a physical court.
Oh. For some reason, I asked him that when he talked to me. Now, Mr. Brown, I guess, are you all gonna, so the Woods and Rose, they're set for the 16th.
How could we, I mean, I haven't gotten an offer from the state.
Oh, you have?
No.
Oh, well, then.
This person named Joseph.
Joseph Woods, And
That's a hearing case?
and the other case, that Mr. Bridges used to be on, I just got assigned to it. I didn't.
You can just stay on the case and just.
It just worked it out.
I guess y'all gonna take care of my children and my grandchildren. Huh? So, I get this board. The smaller thing y'all overlooking there.
So I can, you wanna just reset this for maybe December?
Which case? Both of them?
I would do everybody.
Everybody, December's fine, as
Okay.
long as it's not December 25th.
I'll do it on the 23rd. I'll set it for the 23rd.
Okay.
Let me see, maybe.
You ready?
December 23rd.
26?
Anybody else go back?
You didn't have anything else.
I'm still gonna be going on vacation. I'm just kidding.
Okay, okay.
I think that calendar is gonna be at the beginning of December.
Beginning of
December the 4th.
Okay. I got a special set trial in Henry County, December 4th. Special set murder case.
What's on to January?
January, yeah, I think I'm clear, January. Yes. Please, final plea.
Okay. All right, so.
Oh, Woods Joseph coming out. Sorry, that's fine. That's fine. Well, Barnes and Rose, they. Miss Kathy, y'all don't need Rose either, right? Y'all said Barnes and Rose can go down.
Those roads and woods are together.
Also, Rose has to stay up too.
No, she left. No, she didn't get notice.
Yeah. Woods is on, Woods is his. Woods is young. Woods is young, that's all we got.
Yes. I didn't show Miss Jones.
Oh, she's lovely. Woods is. Woods is young. That's young. So Reed.
Well, I didn't get.
Man, that's good, but I don't. Miss Kathy, we don't need, he's here for Woods. Yeah, I know. So, I mean. Miss Kathy. So they don't always come to court. Yeah, but there's nobody online. And we only had a 1 o'clock phone.
I don't. There's nothing that says he was on. You want to see this?
But it's why I was looking at you, I was like, but you probably ain't really. She get in my court, I let her stop at the door, I don't let her sit down.
So you can just let her know her attorney never showed up.
All the females can go down except for.
Yeah.
Ms. Young is staying.
Okay, but the rest of them can go down, because I thought you told me to keep reading up too.
Well, her attorney has not shown, so I don't know what happened. Y'all both have it?
We're finna take them down now.
Wait.
Just wait, bro.
Yeah, yeah.
I got easy at 4:30.
Bruh, it's
You a rendezvous or something? You trying to meet with somebody?
Hey,
Trying to get out of here.
I got no miss room when you at 4:30. I make sure I get off on time.
Oh, you going to the blue plane?
It's not encouraging, y'all. Y'all encouraging it.
That is real money.
I didn't do good money then.
Not
So
that
I
type
got
of
the two sides, you know.
Not that type of money, y'all. Legit, good old clean legit money. Where your mind at?
Huh?
Where's your mind at?
They went to college.
No, that I got that associate. I was
You
done.
know what Miss Elliott said?
What you say? I want to hear you say it.
Let's go, Kathy. What she said.
I wanna hear.
There's some words that I can't say in court.
Nobody out, ain't nobody out here judging out here.
I'm gonna go judge real quick. You're ready, right? So
Yeah.
Two of the females can go down right now.
Very
That's
good
no pleas to take.
How many back there?
Three females. Male.
We'll take the two females
My thing-
Howard should be back there.
my thing-
Theo Howard should be meeting you back there.
Okay.
Who else you need to take, let him know.
Okay.
I don't know, you. Who took their lunch already? I haven't.
Me neither.
Hmm?
Neither one of us.
Neither one? So Hope was here. Nobody took lunch. I told him.
Sarge, it was 11 o'clock in the morning. You should take-
Somebody who ain't gonna get it now.
I brought mine.
Okay. All right, neither have I. So your judge don't have his lunch?
You don't do lunch.
He don't do what?
He's on a hunger strike. He does it all the time. Right. I yell at him every time.
He gonna mess up his system. Okay, wait till you get older.
He says he's
Having all kind of issues. And he take them down by himself? He taking the female? No. He can take them down. Go ahead. Okay, so. Nobody gets lunch in here.
Mr. Clark, what are we gonna do about our housing issue?
She's gonna have to figure that out when she gets out of the DOC.
Okay.
She's gonna be in there for close
So
to 6
somebody
more
just needs
years,
to talk to him.
probably, so.
Yeah, I guess we'll both be old and gray and be gone.
I'm already gray, so.
Okay, we'll be gray early. So we're just gonna do, we're not gonna do mental health or anything like that, drugs or?
Just,
You just wanted to talk.
Okay.
no, the client wants to.
Obviously, I told
Oh,
her.
that's right, that's right, okay. That's fine.
And don't return to the location.
Yes, I'm gonna go ahead and sit down.
Yes, ma'am.
I gotta tell you.
I like him too, yeah. Mhm.
Deputies here.
Just don't record my off comments.
I started expert old bars and bananas.
Get him snack.
I can
I can tell.
We got crackers, we got cookies, chips, pretzels.
You gotta eat a real meal.
We've got nature bars, those nature things. Food things,
So it's gonna be hard for y'all to keep a deputy.
It's real bad, I'm like this, you gotta stop.
Yeah, he's gonna have to stop it. I understand for himself, but can't be selfish, other folks. Got feelings.
Father. He is
Young.
Court will now come to order.
All right. So you're waiting on your client.
Well, yes, he just wants to hear from you what's gonna take place. And he's probably.
Have you gone back and talked to him yet?
I have spoken. with him.
But he wants to hear from me.
Yes, you are.
All right, well, let's bring him out then before we do this plea.
Where's Johnson? Where's Johnson?
And you're Mr. Brown?
I am, Your Honor.
What's up?
road, okay? I heard it was winter. It was in late brown.
Well, and then we've all,
Yeah, B.
oh, all right.
Cause you know, our gun lockers got different, we got codes. for it. It's not the same code.
I still don't understand all your security protocols, but
We had to switch everything up since we had that little this. With the, YSL.
Contraband.
Yeah.
Yeah.
oh yeah, one of your own.
Mhm. Ms. Robinson, what date did you say that was? 24th? Oh, I thought I heard you say.
24th of what?
No, I heard wrong. I heard wrong.
January of 2024.
I'm game, let's go. December 24th. Everybody be real happy.
Yeah.
Merry Christmas.
I'm saying if you were a citizen.
I'll be Grinch.
Hey, what you say? Christmas, no Christmas. Are you the nightmare before Christmas?
It's Joseph Woods.
Huh?
Joseph Woods. So
Joseph Wood?
which is, so he's got a co-defendant case, and then we're resetting the other stuff as well, because this part's taking over all of it.
Mr. Bridges used to represent him as a defense attorney.
No. Why? Around. In the woods?
Yeah.
Coming to the table.
All right.
Right here.
All right, Mr. Woods, just to give you an update with what's going on. So you have 3 cases. And 2 of them are with Mr. Brown and one of them is with Mr. Is it Bastian? Bastian. And in one of them, we've already reset, you said, to January? All of them. So part of the reason that we have to reset it is because your former defense attorney now works for the district attorney's office, who actually happens to be here right now. But and so he's not able to obviously represent the state against you having been your defense attorney. And so we've now gotten a new prosecutor involved so we can go forward with your case. Do you have any procedural questions? I mean, you have an attorney here who's going to cut you off if you're on the verge of saying anything incriminating. But
When you said I was reset to?
what was the date that we reset it to?
I don't believe the date has been set yet.
All right, so it'll be in January because you're also a co-defendant with Corey Rhodes on one of these cases. All right. Do you have any other procedural questions? I don't want you to say anything that's going to get you in trouble.
I had a court date on October 16th. Would it be for you too?
That was the potential trial date. So this was the final plea for that trial date. But like I said, it's not going to work because Mr. Bridges was your attorney in one of the cases. And we've got to reschedule everything, especially your co-defendant case. And I don't know whether this will all be resolved or not, but we're going to have to go from there. Okay.
Yes, sir.
All right. All right. You're excused.
Be in touch with you.
All right. We'll bring out is it Young? We'll bring out Miss Young.
No, that's my only case. May I be excused?
Yeah, you're excused.
You'll have a good day.
You too.
Have a good one. Merry Christmas.
That's the problem is that I think I've got the reputation as Santa and some of the other judges have the reputation as Grinch, but
Okay, there's nobody else here from that
well, I've got to sit down and work on these orders after this, but I mean, I'm coming home tonight till late. I've got a bunch of orders that I have to, I'm with this on. Elizabeth left. Her favorite civil client, Miss LaRose, was here, and I told her I gave her cell phone number, and so you sent LaRose to McBurney, right?
I just told her she can't be here, Your Honor.
But I think Max told her to go to McBurney since he's presiding judge. That'll be
She
fun.
asked me that too. She said, who's presiding? I said, they not in here. And she said, okay, have a good one. I said, have a good day.
I think Max sent her to McBurney. He'll really appreciate.
I said, Your Honor, why you ain't warned me? So even the other deputy, he knew that she was like a little bit off. I'm looking at, I'm thinking her paperwork was legit until you said, this is not real. This is not.
Well, I guess she's got to serve it to me, but it's not our job to produce the roadmap, especially for civil clients. We're not supposed to be giving legal advice. See, that's.
I was in private practice, yes, for 5 years.
See, criminal is cleaner than civil.
Yeah, in some ways, I suppose, yeah.
We're working on an order for her.
The rule is you're supposed to sort of pull from what you think she